Parliament olwaleero Eyisiza Eteeka Ekambwe kwabo abatunda abakukusa abadiringira mu biragalalagala okubiyingiza mu ggwanga Uganda okubikozesa era nga buli anaakwatibwa nga diringira biragalalagala abisuubula abitunda abikukusa mu Uganda babikozesa oli wakusibwa obulamu bwonna kye kibonerezo ekisaliddwa olwaleero Palamenti y'eggwanga Uganda oba okuli w'akawumbi k'ensimbi kalamba ng'onookwatibwa n'ebiragalalagala ng'obitunda bizinensi yo obikukusa obikozesa ojja kuwulirwa akawumbi kalamba oba okwata omuwendo gw'ebyo ebiragalalagala by'olina by'obadde otunda okukubisaamu emirundi 3 oliwe gavumenti era kasita banaasalawo nga basinziira ku biragalalagala bebadde otambuza okyasobola okukola ebibonerezo byombi n'osibwa obulamu bwo bwonna ate n'oliwa n'akawumbi kalamba oba n'okubisaamu ensimbi emirundi 3 ez'ebiragalalagala bibadde otunda n'osasula gavumenti ya kuno kati nno n'olwekyo bannayuganda mwenna gye muli adiringira mu biragalalagala akantu kammwe nti omulimu gwaleka bizinensi efudde yenna anaakwatibwa ebyobugagga byonna by'ofunye mu bulamu bwo oba wabijja mu biragalalagala oba tewabijja mu biragalalagala gavumenti ya Mwai Museveni esazeewo leero ng'eyita mu Parliament ng'ekulembeddwamu sipiika Tayebwa bakubikuggyako ebyobugagga bakubiwamba byonna babitwale ate osibwe obulamu bwo bwonna ate oliwe n'akawumbi k'ensimbi luli bibadde nti osasula obukadde 10 era n'okusibwa emyaka 10 kati ebintu ebimu bayinza babyongerayo paka okulaba nga bannayuganda mukomyawo okutunda ebiragalalagala mukomyawo okwenyigira mu kukukusa ebiragalalagala mukomya okunywa ebiragalalagala mukomya okukozesa ebiragalalagala kati etteeka eririwo nti anaakwatibwa obulamu bwo bwonna osibwe oliwa akawumbi ate osobola okusavinga ebikubonerezo byonna n'oliwa akawumbi ate n'osibwa obulamu bwo bwonna n'ebyobugagga byonna by'ojja mu biragalalagala ebyo ne bikuwambibwako n'osigala ng'oli seke kale bino bibadde mu Parliament olwaleero nkusaba okkirize tugende mu Parliament tulabe ng'etteeka lino erikugira abakozesa ebiragalalagala ababisuubula ababikukusa ababidiringiramu nga bizinensi yammwe nti nno obudde bubakeeredde.
Right, Honorable Speaker and Honorable Members, the Narcotic Drugs and Psychotropic Substances Control Bill number 14 of 23, second reading. In keeping with the Rule 131 of the Rules of Procedure of this Parliament, I beg to move that the bill titled the Narcotic Drugs and Psychotropic Substances Control Bill number 14 of 2023 be read for the second time. I beg to move, Right, Honorable Speaker.
The motion seconded. That's Honorable Serwani Ceremony, all UPDF members, Honorable Macho, Honorable Muijuche, Chief Whip Attorney General, Honorable Itungo Songa, Chair Hest, and many members of the House. Thank you. So, Honorable Minister, would you want to speak to your motion? Just briefly, you go through the principles and sometimes objectives.
Honorable Speaker, I would briefly want to speak to the motion as follows. This bill was read for the first time on 23rd May 2023 and referred to the Committee on Defense and Internal Affairs for scrutiny under Rule 129(1) of the Rules of Procedure. The bill is a repository of the latest bolstered efforts against the illicit supply and use of narcotic drugs and psychotropic substances in the wake of the annulment of by the Constitutional Court in 2017 of the previous law, which left a vacuum that now government seeks to fill in order to align to international best practices and to enhance enforcement and prevention measures, as well as the care and management of persons with disorders related to these substances. The risks posed by narcotic drugs and substances, trafficking and use are far-reaching, and if untamed in time, adversely affect the country economically, socially, politically, and even in terms of security. This bill, therefore, seeks to domesticate international enforcement best practices and also, 1, provide deterrent measures against local drug abuse, B, establish mechanisms for the rehabilitation of drug addicts, C, put in place measures to save Uganda from being a transit route and consumer of drugs, D, facilitate cooperation with the international community in the fight against narcotic drugs and psychotropic substances trafficking, and E, establish mechanisms for generating resources for law enforcement agencies. I beg to submit, Honorable Speaker.
Thank you. Thank you, Honorable Minister. Chairperson, the committee, are you ready?
Right Honorable Speaker. I'm here to present a report of the Committee on Defense and Internal Affairs on the Narcotic Drugs and Phytotropic Substances Control Bill 2023. Right Honorable Speaker, I wish to lay on the table the minutes of the meetings of the Committee on Defense and Internal Affairs and the copy of the report, although it was earlier on uploaded. I beg to lay. Right Honorable Speaker, I now present the report. The Narcotic Drugs and Psychotropic Substances Control Bill 2023 was read for the first time on 23rd May 2023 and referred to the Committee on Defense and Internal Affairs for scrutiny under Rule 128.1 of the Rules of Procedure of this Parliament. The committee has considered the bill in consultation with various stakeholders and now reports under Rule 129.2. Background. In a bid to bolster efforts against the supply and use of illicit drugs and substances, the government introduced the Narcotic Drugs and Psychotropic Substances Bill 2023. This followed nullification of the Narcotic Drugs and Psychotropic Substances Control Act of 2015 by the Constitutional Court in the petition of Wakiso Miraa Growers and Dealers Association versus Attorney General, Constitutional Petition number 1 of 2017 for lack of quorum by Parliament while passing the bill into law. The nullified Narcotic Drugs and Psychotropic Substances Control Bill, Control Act 2015 consolidated all laws relating to the control, possession, and trafficking of narcotic drugs and psychotropic substances and the cultivation of certain plants. Consequently, the government retabled the Narcotic Drugs and Psychotropic Substances Control Bill 2023 for the first reading on 23rd May 2023 to provide remedies intended to suppress the problems related to drug trafficking and abuse, to promote international cooperation, and provide the law enforcement agencies with resources to use to curb the problem. Policy and principles of the bill. The policy behind the bill, Right Honorable Speaker, is to adopt measures to criminalize drug-related offenses under the domestic law in conformity with Article 3 of the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances and other related international conventions. The bill, Right Honorable Speaker, is also intended to make provision for a mechanism to generate resources for law enforcement agencies through confiscating money and properties obtained from illicit trading in drugs, provide deterrence against local drug abuse, and put in place a mechanism for rehabilitating drug addicts. Objects of the bill. The bill seeks to A, provide deterrent measures against local drug abuse, B, establish mechanisms for the rehabilitation of drug addicts, C, put in place measures to save Uganda from being a transit route and consumer of illicit drugs, D, facilitate cooperation with the international community in the fight against drug trafficking, E, establish mechanisms for generating resources for the law enforcement agencies. Relevance of the bill. Following the nullification of the Act, there is currently an absence of legislation to deal with increasing cases of drug trafficking and abuse. National Drug Policy and Authority Act CAP 206 in relation to drug abuse is very weak and does not adequately address cases of illicit drugs, especially in the face of Uganda risking being a transit route for drug consumers. Methodology. Right Honorable Speaker, dear colleagues, the committee met with and received written memoranda from the following agencies, ministries, and bodies. 1, Ministry of Internal Affairs. 2, Ministry of Health. 3, Directorate of Government Analytical Laboratories. 4, Butabika National Referral Hospital. 5, Criminal Investigations Department of Uganda Police. 6, National Drug Authority. 7, Center for Legal Aid. 8, Wakiso Miraa Growers and Dealers Association Limited. 9, Uganda Medical Cannabis and Hemp Industry Association. 10, Industrial Hemp Uganda Limited. 11, Human Rights Awareness and Promotion Forum. 12, Uganda Youth Development Network. 13, Legal Brains Trust. 14, Pearls of Africa CBD Limited. 14, members of the Rastafari Community, Uganda. 16, Right Honorable Speaker, the committee also interacted and heard from the Honorable James Baba, Ambassador, Member of Parliament Koboko, who previously was a sponsor of the bill that was nullified. The committee also made abundantly available time and listened to presentation from the Honorable Mwanga Chivumbi, Member of Parliament for Butambara County. Document review. The committee referred to the following documents. The Constitution of the Republic of Uganda.
I have a procedure.
Thank you very much, Right Honorable Speaker. Mr. Speaker, we are processing a law that ran into trouble. Since we have the Attorney General, I seek for your indulgence to help us whether by having another serving military officer, General David Mohoz, involved in matters that should be brought here by civilian. There's something wrong with generals with that name. Whether we will not run into the same problem. Because you remember this parliament set a precedent. When General J.J. Odong was appointed, parliament refused to approve him until he resigned. I now see another general, people will go to court challenging the Attorney General can tell us whether General Mohoz can engage himself in partisan issues.
Thank you, Honorable. Honorable Semuju, we are processing a government bill sponsored by the Minister for Internal Affairs, Major General Kaindo Tafiri, who is a retired army officer. So when we are addressing these matters, we go to who sponsored the bill. But even then, General Muhoozi is here as an elected member of parliament. He has the same rights as you, because the Constitution provides for election of members of parliament to represent the UPDF. Unless we amend the Constitution, whatever he says here is substantively provided for under the law. Thank you. Yeah. Now let's move on. I know you have a problem with the name Muhoozi, so we can advise him to change his name. Then you can be comfortable when he's here.
Thank you. Thank you, Right Honorable Speaker, for your wise ruling. Document review. The committee referred to the following documents: the Constitution of the Republic of Uganda, 1995 as amended, the National Drug Policy and Authority Act, the Medical and Dental Practitioners Act, Cap 27, the Pharmacy and Drugs Act, Cap 280, Veterinary Surgeons Act, Cap 277.
But colleagues, when did the procedure issues start coming when we are reading reports? Just the chairman is reading a report.
Yes,
Yes, yes, Honorable Ruhunda.
with due respect, Right Honorable Speaker, I see the report. Yeah, the report by the chairperson is a very long, voluminous report. Now, if we go page by page, it is going to take us a very long time to process. So I would wish that he summarizes, because we have had this report.
Now, no, honorable colleagues, I think this is a problem of us not reading the reports we have. The report by the chairperson is only 15 pages. Just 15. You can see it very big, but these are areas proposed for amendment, which we shall handle when we go to committee stage. But the report is only 15 pages and is moving very well. So, and this is a returned bill. This is a bill which has been repealed by court, you know, because of not following clear procedure. But it's also a very critical bill. Very, very, very critical. Very critical. So let's give it time. We are going to give it enough time, and we do a very, very thorough job. But since you've interrupted, honorable colleagues, I just want to take the opportunity to announce that in the public gallery this afternoon, we have students and teachers of Central College, Kabimbiri, Nakifuma County, Mukono District. They are represented in Parliament by Honorable Nabukera Hanifa Hussein and Honorable Fred Simbwa. They've come to observe proceedings of the House. Please join me in welcoming them. You can stand up and colleagues wave at you. Thank you. Also, honorable colleagues, in the public gallery this afternoon, we have members of the Wakiso Mira Growers and Dealers Association Limited, an umbrella of the Uganda Kati Mira Growers and Dealers in Uganda. They've come to observe proceedings of the House, and I can see they have some supporters in this House. So, Chair, please continue, and we conclude with the report so that we go on our law.
Thank you, Right Honorable Speaker. I was on the list of documents reviewed. So we also looked at Veterinary Surgeons Act, Cap 277, Criminal Procedure Code Act, the Penal Code Act. We also reviewed international instruments, Right Honorable Speaker and dear colleagues. We looked at United Nations Convention Against Illicit Trafficking in Narcotic Drugs and Psychotropic Substances of 1988. We looked at the Single Convention on Narcotic Drugs of 1961. We also looked at the Convention on Psychotropic Substances of 1971. Right Honorable Speaker, there are salient observations on the bill. The question of whether the consideration of the bill before the committee was sub judice as provided for under Rule 73 of the Rules of Procedure of Parliament. Right Honorable Speaker and dear colleagues, while considering the bill, the committee established that the Attorney General had filed a notice of appeal, Appendix 1, against a decision of the Constitutional Court in Constitutional Petition number 1 of 2017. Wakiso Mira Growers and Dealers Association versus the Attorney General of Uganda, dated 5th May 2023, following the nullification of the Impugned Act. After court declared the Narcotic Drugs and Psychotropic Substances Control Act of 2017 null and void for lack of quorum when it was passed, the committee wrote to the Attorney General, Appendix 2, seeking clarification from the status of the appeal. The Land Attorney General responded, and his response is Appendix 3, that 1, the Attorney General's chambers had not yet lodged a memorandum and record of appeal in the Supreme Court, as the record of proceedings has not yet been availed by the Court of Appeal. And 2, a notice of appeal cannot be a bar to Parliament exercising its legislative function. Following the advice of the learned Attorney General, the committee proceeded to consider the bill. Rationale of the Narcotic Drugs and Psychotropic Substances Control Law. There is, Right Honorable Speaker, there is a growing legalization of drugs, in particular, cannabis around the Western world, and currently slowly manifesting in some parts of Africa and Asia. Increasingly, the circulation of illicit drugs as a result of the legislation developments on the narcotic and psychotropic substances across the borders has shot up due to globalization. Illicit drug use is a global public health problem with adverse health effects, socio-economic consequences. In Uganda, there is increased documented drug abuse among particularly youth from wealthy families and students, as evidenced by the increasing numbers of youth at Butabika Mental Referral Hospital. Uganda is a signatory to the United Nations treaties like the Single Convention on Narcotic Drugs of 1961, the Convention on Phototropic Substances 1971, and the United Nations Convention against illicit traffic in narcotic drugs and psychotropic substances of 1988. The treaties contain obligations whose compliance with state parties plays a significant role in controlling the illicit inflow of narcotic drugs within the jurisdictions of state parties. The committee finds that these treaties impose an obligation on state parties to comply with efforts to control illicit inflow of narcotic drugs within jurisdiction of state parties. Right Honorable Speaker, despite being a state party to the Single Convention on Narcotic Drugs of 1961, Uganda still grapples with drug trafficking. The three international control conventions are not self-executing, and their provisions must be incorporated into domestic law by legislative acts. Right Honorable Speaker and dear colleagues, the existing National Drug Policy and Authority Act does not explicitly provide for prosecution for drug trafficking in narcotic drugs, but provides for unlawful possession. The Penal Code Act, Cap 120, contains no provisions directly related to drug use in Uganda. The narcotic drugs are in various forms, ranging from plant leaves, fresh or dry, to tablets, white powders, and clear liquids. Because of their pharmacological profile, controlled narcotic drugs and psychotropic substances can compromise health and human safety if used outside the structure of sound medical practice. Right Honorable Speaker and dear colleagues, consequently, the 1961 Convention calls for establishing a drug control system where state parties commit themselves to accurately and responsibly managing these substances. Therefore, the bill before us will address the misuse of narcotic drugs and psychotropic substances. It essentially adopts the approach of controlling narcotic drugs and psychotropic substances concerning the possession, trafficking of narcotic drugs and psychotropic substances, and cultivating certain plants. The state seeks powers to restrain persons suspected of having committed offenses under the Act from using any or all of their property, and to trace, confiscate, and consume proprietary rights over persons convicted of specified offenses. The committee, Right Honorable Speaker, observes that if enacted, the bill will significantly help Uganda's fight against the abuse and trafficking of illicit drugs, both internally and across borders. Additionally, it will create a regulated mechanism of usage and trade in controlled drugs and substances, and hence facilitate Uganda's commitment to meet her international obligations regarding control of drug trafficking. The mandate of different ministries under the bill. The mandate of ministry responsible for health in the control of narcotic drugs and psychotropic substances is to regulate the permissible use, manufacture, and storage of narcotic drugs as provided for by the Single Convention on Narcotic Drugs and Psychotropic Substances, 1961. Convention recognizes that the medical use of narcotic drugs continues to be indispensable for relieving pain and suffering, that adequate provision must be made to ensure the availability of narcotic drugs for such purposes. Therefore, the bill in clauses 9, 10, 11, and 14 deals with the restricted use of narcotic drugs prescribed by medical practitioners, pharmacists, dentists, veterinary surgeons, and rehabilitation centers under Part 5, regulated by the institutions under the ministry responsible for health. The Ministry of Internal Affairs is responsible for enforcing the law, conducting investigations in case of breach. The committee posits that all licenses and permits to be issued under this act should centrally be issued by the ministry responsible for health, since the permission to use narcotic drugs and psychotropic substances is restricted to only medical purposes. The Ministry of Internal Affairs should remain the enforcement arm of the government to ensure compliance. Right Honorable Speaker, the highly contested narcotic drugs and psychotropic substances in the bill. The world over, there is an increasing demand to strike a balance between management and control of narcotics under the international conventions, vis-a-vis the overarching desire to ensure the availability of controlled substances for medical and scientific purposes, whilst preserving mentally stable societies. The committee, from its interface with stakeholders, gathered sufficient scientific literature and evidence from both government and private experts on pharmacology of Catha edulis, brackets or known as CAT, also known as Mira, or Mairunji, and cannabis or marijuana, which are highly contested. One of the grounds of petitioners put to court for nullification of the law on narcotics and psychotropic substances in the Wakiso Mira Growers and Dealers Association Limited versus Attorney General of Uganda Constitution petition number 1 of 2017 was that the prohibition and criminalization of the cultivation, possession, consumption, sale, purchase, warehousing, distribution, transportation, exportation, importation, and other dealings in Catha edulis or CAT are incorporation of CAT within the definition of the term psychotropic substances, breached several provisions out of the Constitution. Further, the fourth schedule of the bill under consideration now proposes cannabis as a prohibited plant. As such, the committee deems it necessary to appreciate the pharmacology, cannabis, and the effects of CAT and cannabis to inform the House on the plausible way forward. Right Honorable Speaker, cannabis or cannabis sativa, commonly known as marijuana, hemp, or ganja, etc. What does the committee talk about this? The Director, Government Analytical Laboratories, informed the committee that cannabis was a flowering plant that produced 120 unique cannabinoids. It includes species of cannabis sativa, cannabis indica, and cannabis rudelasis. These plants' morphology contains chemical compounds that interact with endocannabinoid system in the human body if taken. This system is critical in various psychological, physiological processes, including mood, memory, pain, sensation, and appetite. Right Honorable Speaker, the most well-known cannabinoids are delta-9 tetrahydrocannabinol or THC, and cannabinol CBD, the THC is responsible for the high often associated with its consumption. It works by binding the CBD, the CB1 receptors to the brain, which mainly found in central nervous system. CBD is a non-psychoactive cannabinoid that has gained significant attention for its potential therapeutic effects. Notably, the Director, Government Analytical Laboratory informed the committee that cannabis offers a rich reservoir of bioactive molecules that can be used in pharmaceutical, nutraceutical, and cosmetic products. Cannabis materials include dried ground buds, flowers, stems, stalks, leaves, seeds that can be classified under 4 categories based on the total THC content. These include low THC cannabis, that is derived from cannabis strains or cultivars bred to have low THC below the level threshold defined by each jurisdiction. This is most sought after for its higher CBD content and potential therapeutic benefits with minimal psychoactive effects. 2, high THC cannabis, which is derived from cannabis strains bred or selected for their elevated levels of THC, typically above the legal threshold defined by each jurisdiction. This category is mainly sought after by users seeking stronger psychoactive effects and euphoria for recreational purposes. 3, marijuana, that is mainly derived from cannabis varieties with higher THC levels and primarily grown for recreational or medicinal use. It is rich in THC and has varying levels of cannabinoids, including CBD. 4, hemp, mainly derived from cannabis strains with deficient THC levels 0.3% or less dry weight percent total THC in the US and 0.2% THC in many EU countries. Hemp is cultivated for various industrial purposes, including fiber, seeds, and CBD extraction. It has minimal psychoactive effects due to its low THC content. Right Honorable Speaker, currently, the licensing of cultivation of plants yielding narcotics in Uganda is the minister responsible for health in consultation with the National Drug Authority under Section 49 of the National Drug Policy Authority Act, Cap 206. To this extent, the committee was informed that Industrial Hemp Uganda Limited, a limited by guarantee company, was one such licensed company currently growing and processing medical cannabis. I have provided tables and the report that contain medical pros and cons of cannabis. I beg that I continue because this literature is provided, even if I don't read them. The source of this is the Directorate of Government Analytical Laboratories. So it's an authoritative literature to guide us. The committee noted that due to its therapeutic characteristics, the importance of cannabis in the pharmaceutical healthcare industry is increasingly gaining traction. Many states in the US and countries in the West have approved medical cannabis or medical marijuana, and the sector is one of the fast-growing markets as more and more countries legalize it. However, the committee observes that whilst some jurisdictions have relaxed restrictions on cannabis, its abuse over psychotropic effects is more profound, and this continues to pose severe risks to public health. Directorate of Government Analytical Laboratories revealed that from its statistics of forensic casework from January 2021 and June 2023, this is recent statistics, it retrieved 178 cases of narcotic drugs in 2021, 295 cases in 2022, and 83 cases from January to June of 2023. From these, Right Honorable Speaker and dear colleagues, cannabis was the most abused drug, making 68.2% in 2021, making 80.1% in 80.1% in 2022, and 76.4% in 2023. It was found that cannabis was largely affordable and associated with criminal cases related to theft, burglaries, violence, and accidents. Right Honorable Speaker, the committee interrogated the efficacy of literature and medicinal effects about Catha eduris, or cat, also locally known as Mira, Mairunji, etc. The Director, Government and Analytical Laboratory informed the committee that cat, natively grown in East Africa and the Arabian Peninsula, was a flowering evergreen shrub abused for its stimulant-like effect. The leaves are traditionally chewed fresh and sometimes dried for tea or chewable state. In Uganda, cat has increasingly gained traction as a cash crop due to its associated advantages requiring less labor, small scale of land for cultivation, and ready market for its fresh leaves. Cat's most notable phytochemical compounds include CNS stimulant properties. This is cathinone and cathine, a mild psychoactive alkaloid. The Director of Government Analytical Laboratory further noted that cat contains several stimulant compounds, including cathinone, cathine, and morphedrine, which are alkaloids primarily concentrated in the plant's fresh leaves. These are classified as phenethylamines with stimulating effects when chewed. Cathinone is structurally similar to amphetamines, acts as central nervous system stimulant. Its effects include increased energy, euphoria, and alertness. It is considered the main active compound in fresh cat leaves. Cathine, also known as...
Honorable colleagues, I need you in the House. Honorable Ministers, I need you in the House. We need quorum. This is a government bill. I need government officials in the House. We are doing government work. Please. Yes.
Thank you. Right Honorable Speaker.
This bill was nullified because of quorum. If I cannot get quorum from government on a government bill, then it will be difficult for me to proceed with work.
Right Honorable Speaker, structurally related to cathinone and has similar stimulant properties. Although milder, cathinone in Schedule 3 controlled substance in the US due to its stimulant effect. Table 2, Right Honorable Speaker and dear colleagues, has pros and cons of cat. I beg that members read it. I can go, and this literature and statistics is got from Directorate of Government Analytical Laboratories. Right Honorable Speaker and dear colleagues, the World Health Organization considers cat a less potent or addictive stimulant that other commonly used substances such as alcohol, cocaine, amphetamine, and tobacco. The WHO expert committee, upon review of the compounds in cat, determined that the potential for abuse is low and the level of threat to public health is insignificant to warrant international control. The committee is mindful that highly contentious plants have a robust historical connotation, particularly in Africa, where they have been used as medicinal plants or local herbs. Additionally, Right Honorable Speaker and dear colleagues, from a global perspective, there is a growing debate on how holistic approach to controlling psychotropic substances for medical purposes can be achieved without endangering the young generation. However, the use of drugs for recreation has increased in the last century, owing to developments in science and technology. The committee was informed by the team of expatriates from Butabika National Mental Referral Hospital that more recently, the research and studies conducted at the hospital have shown that cannabis has increasingly become a gateway drug for use of other hazardous substances. Additionally, no controlled studies or clinical trials declare cat medicinal. Some studies also argue that heavy cat use has been documented to be a recipe for family breakdown and intoxication among young persons. But still, there exists no concrete scientific evidence linking crime and cat use. Also, no quantitative data is available about the prevalence of public health problems, severe or otherwise, associated with the use of cat. Furthermore, 3 United Nations conventions that form the international legal framework of global drug and psychotropic substances control, that is, the Single Convention on Narcotic Drugs, as amended by the 1972 protocol, the Convention of Psychotropic Substances in 1972, the Convention Against Illicit Traffic of Narcotic Drugs and Psychotropic Substances, 1988, all of which Uganda is a signatory to, do not classify cat as an illicit or prohibited substance. However, Right Honorable Speaker, and dear colleagues, consumption of cat in Uganda has not been a common phenomenon. It is a recent development attributed to the high influx of refugees from the neighboring countries where cat is traditionally consumed. This has increased the demand and market for cat in Uganda. From the Directorate of Government Analytical Laboratories, statistics of forensic casework of January 2021 to June 2023, highlighted above, Right Honorable Speaker, it was further revealed that cat made up to 1.3%, 0.6%, and 2.2% of the total drug cases received in 2021, 2022, 2023, respectively. Drawing from the above, the uncontrolled consumption and distribution of cannabis, cat, and other synthetic drugs continues to pose a significant public health risk to the young population. As such, the committee deems it necessary to ensure public health by prohibiting cannabis sativa and Catha iduris. Under a highly controlled legal regime, the international obligations notwithstanding, the 2 plants, that is cannabis and cat, should only be allowed for cultivation and usage strictly for medical purposes and research. Right Honorable Speaker, protection of our children. Clause 10 of the bill prohibits the supply of narcotic drugs and psychotropic substances to any child by any person, including a medical practitioner, pharmacist, or dentist, without reasonable grounds to believe that the child requires such substances for medical purposes. Under Article 33 of the UN Convention on Rights of a Child, the obligation to protect children, young people from harmful drugs cannot be overemphasized. The drug supply chain and narcotic drug substances puts children at risk of harm. Children are harmed through drug use, parental drug dependence, drug-related violence, exploitation in trafficking, and range of other ways. Considering the detrimental effects of narcotic drugs and psychotropic substances, and in the attempt to domesticate the spirit of Article 33 of the UN Convention on Rights of the Child, the committee finds it necessary to propose more stringent measures to mitigate the supply. To this extent, the committee proposes to increase the fine and the jail term for the person who exposes the children to drug abuse. Conclusion. Right Honorable Speaker and dear colleagues, the bill seeks to adopt measures to criminalize drug-related offenses under domestic law in conformity with Article 3 of the United Nations Convention Against Illicit Traffic in narcotic drugs and psychotropic substances and other related international conventions. The committee reviewed the bill and made proposals that it deemed fit to achieve the set objectives. The committee was alive to the need for comprehensive review, for comprehensive and responsive law that addresses supply, demand, and harm reduction in the use of narcotic drugs and psychotropic substances while prioritizing public health. Right Honorable Speaker and dear colleagues, the committee recommends that the bill be considered for the second reading, subject to the proposed amendments attached here too, and any other modifications the House may propose to approve. Before I report, Right Honorable Speaker, I also must mention that this report has a minority version. Under your guidance, you probably give them a chance to propose it. Right Honorable Speaker and dear colleagues, I beg to report.
Thank you. Yes. I think consultations are still going on outside. Colleagues, as you remember very well, the presiding officer, then the Right Honorable Speaker, guided that the Committee on Health should also look at the bill and incorporate its recommendations to those of the Committee on Internal Affairs. Unfortunately, under our rules, the recommendations of the Committee on Health cannot be reported upon here because we can only have one report, only one committee, or if at the beginning jointly they had been guided to process the bill together. So yesterday we held a meeting where the Minister for Health, the Minister for Internal Affairs, the Attorney General, Chairperson Committee on Health, and brought the recommendations and observations of the Committee on Health, those which had been considered by the Committee on Internal Affairs and additional issues which they felt the Committee on Internal Affairs had not addressed properly. So I guided the chair of the committee that since we don't have any room under rules of procedure where he could make another report, he will, on behalf of the committee, as any other member, present the proposed amendments once we reach on committee stage. So that one should be noted. And I guided him that those proposed amendments should be uploaded because he has read through the report. And I'm sure that was done. So when we reach at committee stage, that's when we will handle the issue. Number two, also the meeting was attended by the Shadow Minister for Internal Affairs, who had also moved a minority report. One issue, he had raised two major issues. I know you read the report. One was on the sub judice rule, where we explained to him because the Attorney General had not wanted to appear. But in the ruling, the judge had pronounced himself on issues related to how we process business here, which we felt we are going to curtail the process of doing business in the House. So we requested the Attorney General to appear specifically on those issues, but not to do with the bill. Otherwise, he couldn't appear on the bill and then again bring it here for processing. So we agreed with the Shadow Minister. I don't know if, but he had another issue where he said he was not yet satisfied. So he's consulting the Attorney General, Opposition Chief Whip. I don't know if you could check on them and see, because I want to give him an opportunity. Number three, I read through the report of the Committee on Honorable Colleagues, and following the practice we've had in this house, whereby if proposed amendments are more than 50% of the clauses in the bill, we usually require the minister to withdraw the bill and go and bring a fresh bill. But that's not a given. That is if the proposed amendments do fundamentally affect the principle and object of the bill. I read through all the proposed amendments from all sides. I found they were all still complying with and principle of the bill. They were mainly around issues of reconciliation. Some were consequential amendments, corrections, and all those few things. So the object and principle of the bill has not been affected by the proposed amendment. And because of that, I allowed the bill to continue being processed. So I now request Honorable Abdallah Chwanuka. Yes, procedure. You have a, yeah. Oh, you have a comment?
I have a motion, Mr. Speaker.
Yeah.
In the past, this parliament to allow the passage of a bill that was removing the age limit to allow President Museveni rule for life. The motion I have is to suspend the rules to allow the Committee on Health, because this is a very serious matter, make a presentation so we can debate with full knowledge, especially implication about health. So my motion, Mr. Speaker, is to have the rule you have quoted suspended to allow the Committee on Health a report. I thank you, Mr. Speaker.
Is the motion seconded? Honorable Musira John, Honorable Aaron Mayanja, Honorable Timu Giwi, Honorable Basri, and many members. Okay. This is the direct motion for which we don't need to, okay? But the problem is, I know he has a report. The biggest problem we have is that there is no rule to suspend, okay? Because there is no rule prohibiting them, and there is no rule allowing them. By maybe, okay, if we could look at the general thought of the speaker and I share it with you, and we allow. So with that, the chair Committee on Health is here. Yeah. So Honorable, you may, if I give you, because it's just general observations you made. Most of the issues from the report you made, I can say they are strictly under the proposed amendments. So if you could see the missing gaps so that members can pick on them, please. Then Honorable Jonathan Odu, let's do this together, Honorable colleagues, so that we don't have.
Mr. Speaker, I thank you so much. Mr. Speaker, I want to speak in opposition to that motion thank you for the following reasons, Mr. Speaker.
Point of order.
Mr. Speaker, to challenge the ruling of the Speaker under the rules is not casually done that you stand and say, now I want to challenge the ruling. When I moved the motion, you asked the colleagues to stand up and you said the chairperson come and present. That becomes a ruling of the Speaker. And the Honorable Jonathan Odul, who is a lawyer, knows that rules, you don't wish them away, that you stand up and say, now I am opposed to a decision already taken, Mr. Speaker. Is the Honorable Jonathan Odul in order to attempt illegally to reverse a decision of the Speaker on this matter?
You see, colleagues, Rule 87, provides for challenging the decision of the speaker. But here it's not a matter of who is in order, who is not in order. I think what I'm getting from both colleagues here is one, Honorable Jonathan would want us to follow the rules to the letter and how they are. But then Honorable Semuji is also saying that the Committee on Health might have discovered very critical information, which would help members when they are debating and making a decision. So both of you are right, okay?
Mr. Speaker, I thank you so much. And I thank my brother, Honorable Semuju, for acknowledging that I'm a lawyer. Lawyers have a tendency of looking at things that are beyond ordinary eyes. Mr. Speaker, the motion had not been carried for the record of the House. The motion had not been voted upon. It has not yet been carried. So I cannot be faulted for making arguments against it. Secondly, Mr. Speaker, I wanted to persuade you can then persuade this parliament to adopt the recommendation so that we stick by the rules of the game. Otherwise, you do not have the provision in our rules to anchor, to even entertain the report. How will you deal with that report in case there are disagreements? So it would fit when he debates and presents it as the first priority, and then Parliament can then take a decision on it. I thank you.
Thank you. Now, you see the end result is the Committee on Health presents, okay? But not in form of a report. I had just used my general authority. Yeah, because I'm trying to avoid the situations whereby really one committee which was assigned the duty, and you know, bills are totally different. Bills are totally different. And even that's what I told the chairman of Health Committee. I said, I will give you an opportunity at a later stage where you can come and you bring all your issues. That's why he's even on the front bench, because I was aware about what the rules tell us to do and not to do. So I think it's a good meeting point. It's a good meeting point. So let's go with the suggestion of Honorable Jonathan Odur, because in the end, we shall have addressed concerns of the House. And initially, that's how I had looked at it. It would be more organized, okay? So let's allow the shadow minister, Honorable Seungu. Let's.
Honorable will say that the lawyers look beyond the eyes. I also want to thank him. Ordinary eyes, whatever he said, still gives the same message. In your ruling, the honorable member, Honorable Semuju, my friend, stated that you want to suspend the rule. And on the record, it reads that he wanted to suspend the rule, yet was moving a motion. For proper records of Parliament, I would pray through Mr. Speaker that you correct that record that the honorable member has moved a motion by not suspending the rules, because we are custodians of the law. And whoever will come after us will look at the same. That no somebody was suspending it. There was nothing like that rule at the time we moved it. Thank you, Mr. Speaker.
Let the Hansard capture that. Honorable Abdara.
Thank you, Right Honorable Speaker. Right Honorable Speaker, with your wise guidance, I retreated with the Attorney General, together with the Solicitor General and the Honorable Mwanga Chivombi, regarding the two limbs of the minority report. And we have resolved to harmonize the issue at the committee stage. And that is regarding section 1 of the bill, where we are going to clog it there regarding the commencement. So we have agreed to abandon the minority. We shall resolve it at the committee stage.
Thank you. Thank you, Honorable Abdallah. Our colleagues, now I will this procedure.
Mr. Speaker, I am not a lawyer to see what the ordinary eyes don't see. But I am an MP who has been here for a while. this is the first time that reports are being negotiated. Because the moment a report is presented and is announced as a report of a committee, a minority report is part of a report of the committee. Let the lawyers who see beyond the eyes tell us whether in our rules there is a provision to negotiate reports and then you come and withdraw. Because the rules require that after the presentation of the minority report, the main report, the minority report will be presented. If negotiations are ordered by the speaker, they can be on matters that all of us know. That's the procedure issue, Mr. Speaker, I am raising.
Yeah, thank you. Honorable, a minority report is at the discretion of the signatories to the report. They can present it, they can decide not to present it. And we've had it here before, where by the way we've received the notice and what, and you wait for the one presented and is not here. In fact, the Honorable Abdara Kwanuka has done something gracious by appearing. Others don't even appear. So a member has, because this is not a report of the committee, it is a report of the people. Listen to me. It's an addendum. It is part of the committee report that has been presented. And the two members who have signed, okay, if they've agreed to withdraw and they've seen their issues have been addressed, there is nothing wrong with that. Moreover, when we reach at that stage, if you are a member of the House and you had been convinced by the issues in the minority report, once we got committee stage, you would have the latitude to raise your issues. Please, let's move. You can raise this during the debate. Colleagues, let's move. I want us to move. We are now going to open up for debate. The debate is limited to the object and principle of the bill, not general clauses of the bill. I open the debate starting with the chairman Committee on Health, as we have agreed to make general observations which can guide us. We shall have a debate for 30 minutes. Then we go to committee stage. We start handling clauses seriously. So clerk and whips ensure members are in. In the meantime, I want clerk to be ascertaining quorum. I want clerk to ascertain quorum both online and in the house. Thank you. Chairman, Committee on Health, I will give you 5 minutes.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, like you had guided, the Committee on Health came up with amendments, as you had told us that we're not going to have presentation of a report. But if I can get the highlights that of our report that speak to the amendments. The issue of narcotics and psychotropic agents is more of a public health issue, because everything ends up in the hospital. It's a public health issue. And these public health threats are emergencies, and some are chronic and terminally. They affect all the systems of the body, honorable members, including the central nervous system, episodes of depression, sexual dysfunction, and so forth, the cardiovascular system, gastrointestinal system, endocrine, and also in the administration of these narcotics and psychotropic agents. Right Honorable Speaker and colleagues, people do share the needles. So we are able to transmit diseases like hepatitis, HIV among, and of course the end point on the body that these narcotics and psychotropic agents affect leads to death. However, Right Honorable Speaker, one of the glaring issues we found, which may present a big legal challenge, is the issue of precursors. Precursors are the building blocks that we use to make synthetic narcotics. Most of the narcotics we think that we deal with, like hemp, cannabis, marijuana, those are grown. But some people exploit the lacuna in the legal system to import the building blocks, bring them in country, and assemble them. And that's where, as a committee, we thought we needed to also scrutinize, because when you look at the World Mental Health Report, one of the biggest problems is synthetic narcotics. So as a committee, we propose.
Sorry, Chair. Colleagues, we have free seating. We have free seating so that we can all fit in.
Thank you, Right Honorable. So as a committee, honorable members, we proposed to add another schedule that lists all the precursors, the building blocks, so that these are able to be regulated. And that helps interpretation of the law, so that when somebody is importing in these precursors, we should be able to know why is he importing them and also for what purpose. And there should be an element of traceability and their regulation. Secondly, Right Honorable Speaker and colleagues, the issue of rehabilitation. We also said the rehabilitation is ideally, treatment precedes rehabilitation. And therefore, the section that caters for rehabilitation, we added the word treatment and rehabilitation because the health sector is better placed to treat the people suffering from the effects of narcotics and psychotropic agents. And then, of course, the rehabilitation. There were issues to do with entities that have been introduced in the bill, like there's the National Committee on Narcotics and Psychotropic Agents. And the committee says that we have a health advisory board that is anchored in the Mental Health Act. And there'll be duplication. Right now, we are transitioning to rationalization. We should not have two entities housed in different acts that are repeating the same function. So the committee says that the Health Advisory Board should take over the regulation and consequently advise the minister. Right Honorable Speaker, there was the issue of possession of some of the narcotics and psychotropic agents. The committee proposed that we needed to open up and give the minister within her mandate in the regulations an opportunity to keep on revising those people, because the health sector is dynamic, it's moving forward, people are super specializing. So in 2 years' time, you'll get a new crop of health cadres that should be able to administer these psychotropic agents, and would not want to come back to the House for an amendment. So we had to propose that. And then secondly, Right Honorable Speaker, on the issue of morphine, the Palliative Association of Uganda was concerned that morphine is administered by nurses for people who have cancer and terminally ill diseases. However, we have—
Honorable Muma, kindly take your seat. Go on, Chair. Go on, Chair.
So going by what the bill had proposed, we would tie out the nurses who go for home visits and administer morphine. So with consultation of the Minister of Health, we opened it up to include clinical officers and senior nursing officers who are trained in palliative care, with another provision that the minister may make guidelines and provisions based on the emerging cadres in the health center. So, Right Honorable Speaker, in summary, as you had guided, you had given me 5 minutes. Those were some of the sticky issues. The rest, we shall handle them when we go to the committee stage in the amendments. Thank you.
Thank you. Yes. Honorable Aisha Kawanda, Honorable Komakech, Honorable Chiwoga, Speak Honorable Rusakero, then Honorable Tebandeke, then I will go here. 2 minutes each.
Thank you so much, Right Honorable Speaker. And I thank the committee for a very good report. We just had a lawyer speaking that he looks at issues as a lawyer. And I would like to say each one of us looks at issues with the proficiency he has. Whereas some people look at this bill from a health perspective, others look at it from a security perspective, and others look at it from an economic perspective. It's wrong for someone to come and say, do not talk about economics. We must, because economics lead to other things. Right, Honorable Speaker, all the things that have been, and I will specifically talk for cards, that's what I understand, because I have many people in my constituency that grow cards. All the things that have been blamed of cult, I want to say that alcohol causes them. And Uganda is #1 alcohol consumer in Africa. Actually, it's the only thing we lead in the world in Africa, is the alcohol. Yesterday, the minister said we lead at coffee. No, we don't, we are #2. I have not seen this country say we stop alcohol consumption because it has these effects. Instead, we are looking forward to more being sold so that we can raise taxes. Right, Honorable Speaker, in my culture, if you want to pick a knife from a child, you provide that child with a stick to hold. You just don't take away a knife because that child will look for something more dangerous. People in my constituency survive on cat. If government is to take away cat from people that survive on it, we must provide an alternative. I have not seen, I have 2 minutes. They will not allow me to come back. Yesterday, we had the Minister for Agriculture saying no more seedlings. Finance saying no money. When you're saying no to every avenue and you have not provided an alternative, how would you expect those?
Thank you. Honorable Komakech.
Right, Honorable Speaker, thank you so much.
Colleagues, you will have more time when we're on committee stage.
Right, Honorable Speaker, thank you so much. I want to thank the committee for the good report. Right, Honorable Speaker, today we debate a bill that entails the life of Ugandans. Right, Honorable Speaker, we are debating about a bill that causes a disease that is incurable. Honorable members, anyone who uses marijuana cannot get treatment and get cured. I would rate an addict as a patient who has HIV, who has TB. We can treat these addicts, but we can never cure them in any way. When you look at the economic bit of it, right, Honorable Speaker, the economic bit will not warrant lives of our youths in this country. Every day in Butabika, from experience, I would work on 8-hour shift. In the 8-hour shift, I would admit 20 young youths. These are Ugandans. 20 from use of marijuana, use of Mairunji. Right, Honorable Speaker, I want to interest members on the report from poor families. Right, Honorable Speaker, I would want to interest members in this parliament that Butabika National Mental Institution Hospital in Uganda is not allowed to admit anyone below the age of 18 who is addicted to alcohol or marijuana. Where do these children go? Do they go to Kampiringsa? In Kampiringsa, there are no health workers who can manage these children in Kampiringsa. So members, I beg of you, addiction is a growing disease. You do not start with cannabis. You start with a lower drug. They will start with Cuba. They will start with Shisha. Then they go on upgrading from level to level until when they hit rock bottom. As I speak, members, we have doctors who are admitted in mental institutions and their certificates, their degrees are hanging.
Thank you. Thank you. I think usually in this house, honorable colleagues, we agree when we have a colleague who is an expert in an area, we usually give them more space and so that we run from them. So since we have one of them who has been treating patients at Butavika and he has that experience, let's allow him to conclude. Honorable Kaumakech, conclude.
Thank you very much, Right Honorable Speaker. Members, I want to interest you.
And even those ones who take, if you confirm that you take, I'll give you enough time to explain to us how it feels when you're taking, okay? But you must confess here that you take, okay? So.
Thank you, Right Honorable Speaker. When one is to use drug, he uses because of a reason. And that reason is always cured by a drug. It's true. When one takes in marijuana, when one takes in Mairunji, they get an effect of healing that comes to them. But look at the out end of it. I'll equate it to someone who dances and drums at the same time. We are talking of the brain. It's the same brain controlling these young people. Right, Honorable Speaker, in this parliament, right in here, I wouldn't mention names, but I know of parents who have treated who have treated their children and they are grumbling with this disease. Right, Honorable Speaker. Now, the beauty is rich parents can take their children to rehabilitation centers, but poor parents, their children end up on the streets. The children you see along the road hackling phones, those are children of poor parents. So if this parliament can really take into heart parents who can't afford going to rehab.
Thank you, Honorable.
Right, Honorable members, I beg that let us maintain the status quo and pass this bill for the betterment of our country. Thank you so much.
Honorable colleagues, there is a very important point a member has raised, that you start slowly. It's like in life how you progress. You when you get money for a border, you now go for your money for a car. You start from a Primo. Then when money comes, you go to Mark II. From Mark II, you go to Subaru. From Subaru, you go to Benz. From Benz, you go to Lamborghini. And then you go to a plane. He has given, that's a very, very comparing point which we should look at. Yes, I had picked you, Honorable Correct. Yes. I had picked Honorable Christine. Honorable Chivumba, I had not picked you. I have already picked the members to speak.
Thank you, Right Honorable Speaker, and the committee for the report. Right Honorable Speaker, they have raised different sectors as they are affected by the issue, but the spiritual perspective, we also needed to hear from it. Because when you look at the contradictions, many of us refuse to take alcohol because of the after effects. The biggest challenge we have here is to allow production, and then from production, we would expect that it is exported, probably it is consumed by other countries, but our ability to control consumption from production, I think, is the challenge we have as Uganda. Currently, I see no funds to monitor adherence to mechanisms that we are providing for. Who exactly is going to monitor that from production, our people don't access? That is where the challenge is. And then you find that some people earn from this. We cannot just look at earning alone, but the corruption of the brains and the ability to think by the population that we have right now is also very important. So I would implore members to look at the rehabilitation process, processes and centers, but there are also very many adults, especially women, who do not consult from their wombs, but continue consuming.
Thank you. Honorable Rusakelo.
Thank you so much, Mr. Speaker, for giving me this opportunity, and I thank the committee for doing a great job. Mr. Speaker, if we look at, I hear people talking about economic gain. Have we even done a study to see how much we end up spending on treatment compared to how much we will gain as a country? We have just talked about rehabilitation centers. How many rehabilitation centers are in Uganda that are treating people for free? Just give me one. None. They are not there and they are not functioning. So what economic gain are we even talking about? At whose expense? And then the other issue is, we are talking about, is it controlled planting? Are we going to put CCTV cameras in these gardens to make sure that we control who goes in and out of these gardens? And then I heard the chairperson talking about that there's no
there is no connection between the drugs and crime. Friends, let me tell you, most of you here are parents. When your children come back from school, ask them whether they have come back with all their property. I know of children when they go to school, they don't have mattresses, the bed sheets are done, the mean is gone, the blanket is gone. Let me tell you, that is a sign that your child is now involved in drug addiction. Because they start small, the cheap one, then they go higher and higher and higher because they want to get the money to buy the expensive ones. They begin to sell things. They even steal your money and you know it. They steal your money because they...
Thank you. Yes, Honorable Tebandeke.
Thank you, Honorable Speaker and the colleagues. Right, Honorable Speaker, in any business, there begins with production and then consumption. I'm not convinced that we shall support the production and limit the consumption. He who plants maize doesn't end up on mere leaves, but even the grains he has to consume. Right, Honorable Speaker, in a religious perspective, I'd like to introduce members to Proverbs chapter 20, verse 1. Wine is a mocker, stronger drink is ragging, and whoever is deceived thereby is not wise. Right, Honorable Speaker, should we get tempted to support the production of marijuana, that is total opium to our minds, and it will relax, freezes, and endorses our understanding? I would strongly support that much as we are in consideration of this bill, we should pass it with strong conditions attached to neither production or consumption, but the status quo has to remain. Because even the existing law, I've not seen any loophole. And even all Ugandans know that anything connected to marijuana is more or less equivalent to treason. Therefore, I think it is this parliament that is introducing the production and the consumption of marijuana to the public, yet the public knows the truth of the matter. I beg to support.
Thank you. Honorable, the law was nullified by court, so we better have a law to achieve what you're raising. Dr. Tahigwa, Linda Irene.
Thank you, Right Honorable Speaker, for giving me this opportunity. I want to comment on the issue of alcohol being psychotropic. Yes, it is, but its effects, the psychotropic effects of alcohol, wear off very fast. Therefore, you cannot compare it with cat. Secondly, Right Honorable Speaker, yes, that we must understand, Right Honorable Speaker, that the two are different. Yeah, they are both psychotropic, but that one of alcohol wears off very fast. Therefore, it does not affect human beings like does cat. Secondly, Right Honorable Speaker, on the issue of production, I think it was clear it should be restricted. It should be restricted, and to me, actually, it shouldn't be, for example, planted within our communities. It should be away from the communities, out of reach of our children. Thank you, Right Honorable Speaker.
Linda, then Peter.
Thank you, Right Honorable Speaker. I would like to thank the committee and to stand to support the status quo of the bill, considering the negative effects that drug abuse has on the young population in this country. Right Honorable Speaker and members, if you can see the increasing number of young people that are mentally sick on the streets of cities, because it's as if when people become mentally sick, they have to run to cities. The numbers are increasing every day. And even when they're already sick, they continue consuming these drugs. So I stand to support the bill that it is high time we have to protect the population of the young people in Uganda. Thank you.
Peter Abraham.
Thank you, Mr. Speaker. Mr. Speaker, in 2017, when this bill was tabled for debate, I recall my brother Kivumbi gave a very convincing argument. And on that day, my argument was, when you compare the move of the president on the 4-acre model, producing 20 million for an household. And my brother Kivumbi was saying, in Butambala, an acre produces, did you say 30 million or something like that? Or more. Today, I've had the same argument from the woman MP, that what alternative do we have for the people in our constituency? I was just wondering, did we hear about the effect of these substances on the population? Number two, you are looking at income for your people. You are not looking at the impact of this activity on the community. I think it's important that if we are going to maintain this proposal by the chair, then we need to register the farmers, gazette where they're going to do cultivation, establish who is going to be buying the product for medical purposes. Otherwise, if every big Tom and Harry has a small garden hidden somewhere, we will not be able to manage the effects of this. Mr. Speaker, I support the bill.
Thank you. Clerk is adding up for me the numbers. I suspend the House for 2 minutes only. 2 minutes only.
Tuli mu Palamenti, abali akakoola, abagaluma. Ebintu birabika bizibu, muyinza obutaddamu galuma wano, n'obutaddamu kutundibwa Uganda. Palamenti omulamwa gweriko nti abagaluma amayirungi, enjaga, ebiragalalagala eby'ekikanga ekyo n'ebirala bimenya ssemateeka kati okubanga bitundibwa mu ggwanga Uganda n'okubirima. Era oyo yenna kati anaakwatibwa ng'abirima bugenda kuba musango munene gwa nnaggumula ng'alina okubitebya era ng'alina okuliwa olw'okuba ng'abadde alima ebiragalalagala ebyo, oba si ekyo okusibibwa obulamu bwo bwonna, oba si bulamu bwo bwonna, olina n'okuba ng'osobola okusibwa obulamu bwo bwonna ate n'okukola n'okuliwa otyo. N'oliwa ate n'osibwa obulamu bwo bwonna n'okola ebibonerezo bibiri omulundi gumu, kijja kusoboka singa n'okwatibwa nga ogenda mu maaso n'okutunda ebiragalalagala, okubisuubula oba okubirya, oba okubikozesa, oba obinuusa, oba obirya, oba obinywa, kyonna ky'obikola.
Give me the numbers you added. Thank you, colleagues. They've counted and physically 177 members present. On Zoom, we have 44 members present, making it 221 members present. I now put the question that the Narcotic Drugs and Psychotropic Substances Control Bill 2023 be read the second time. Those in favor say aye, and to the contrary nay. The ayes have it.
The Narcotics, Drugs and Psychotropic Substances Control Bill 2023, Bills Committee stage. Clause 1.
Chair.
Thank you, Chair. these are proposed amendments to the Narcotic Drugs and Psychotropic Substances Control Bill 2023. Chair, the committee proposes that we delete clause 1. And justification is that the act should commence immediately after the assent and publication to meet the urgency required for the regulation of narcotic drugs and psychotropic substances following the nullification of the current act by court.
Okay, honorable colleagues, anyone with the, it's Honorable Nandara.
Mr. Chairman, I want first of all to agree with the committee because what we're dealing with are drugs, and the drugs have a lot of money. The moment we say a minister should be the one to appoint a day, if we delay by even 1 week, it could be dangerous for us. Mr. Speaker, I want also to agree with the committee to avoid even corruption in this case.
Thank you. Honorable Jonathan.
Mr. Chair, I would like to oppose the proposal by the chair to delete. It's a requirement of the law that you must have a commencement clause, so you cannot delete. We can only amend to read that the act shall come into force on the date of assent.
That's a very important observation, Chair.
Chair, I agree to the amendment. We proceed.
Thank you. I now put the question that the clause 1 be amended as proposed. Those in favor.
Clause 2.
Oh, sorry. I wasn't on record. Yes. I now put the question that clause 1 be amended as proposed. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 1 as amended.
I put the question that clause 1 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 2.
Now, I would want to guide that clause 2, we do it at the end. Wait a bit. When the speaker is speaking, you don't come and say procedure, and you wait till I finish. That's the advantage of being a speaker. Yes. Now, I would propose, like as usual, the practice, clause 2, which is the interpretation clause, we always deal with it at the end, because there are very many salient issues we handle. Honorable Abdara.
Thank you, Honorable Speaker. Regarding clause 1, which is about commencement, it is one of the issues which we had agreed with the Attorney General, and we agreed that we retain it.
Yeah, but that's what we have done, but we have made it better. Okay, if you listened, Honorable Jonathan Odur gave a proposal that we just amend it. Okay, so that we have it with immediate effect. On assent. No,
right.
Honorable, with the law, you can only recommit it because we've already voted on it. So if you have any issue to do with it, you note it down, then you can recommit it at the end once we finished the rest of the work, okay? No, not on clause 1.
Yes. Just provide information, Right Honorable Chair, that usually that provision is put there for the minister to put a commencement date in case he has or she has to make statutory instruments to operationalize that law. But I think in the opinion of the committee, they think it can commence immediately, doesn't require any further legislation by the minister. So I think it should be clear.
Honorable colleagues, please, this is a matter that is sorted. If you have an issue, you will recommit. Otherwise, I don't know what we are doing. It's an already sorted matter. Yeah. So, but you note it down. Any clause where you have an issue, you can recommit. Yeah. Clerk.
Clause 3.
Chair. Clause 3.
Chair, clause 3 is on jurisdiction. We propose that clause 3 is substituted for the following 3. 1, this act on jurisdiction, this act applies to the entire territory of Uganda. 2, this act applies to conduct engaged in, inside or outside Uganda relating to the importation, exportation, manufacture, buying, sale, giving, supplying, storing, administering, conveying, delivering, or distributing of a narcotic drug or psychotropic substance. A, on board a vessel or aircraft registered in Uganda. B, by a Ugandan citizen or any person ordinarily resident in Uganda. C, by a body corporate incorporated in or carrying on business in Uganda. D, any other person relating to the supply or possible supply by that person of any narcotic drug or psychotropic substance. Right Honorable Chair, the justification 1 is for clarity and better drafting. 2, jurisdiction of Uganda covers the territory, the aircraft registered in Uganda, and the ship flying Ugandan flag. 3, to enumerate the actions that will create criminal liability if done in or outside Uganda. I beg.
Yes, Honorable Nandara.
Mr. Chairman, I want to interest the chairman of the committee. I hope you know a free zone. A free zone, it means there are some laws which don't apply to it. And at the moment you allow free zones not to be mentioned here, you are creating that to any place in Uganda gazetted as a free zone, you will allow even, let me give an example at the airport. That means if a plane came flying a Kenyan flag and lands in Entebbe in a free zone, and when it is carrying drugs, it will not be touched. So what we want, that is what you must know. 2, even if you do an industrial park and you say this is a free zone, there are laws which are not applicable in this country. So, Mr. Chairman, I would interest you that free zone should be part to be added on the territorial in Uganda. The justification to avoid anybody to use a free zone as a conduit to bring in drugs.
Attorney General.
Thank you very much, Honorable Chair. I think D addresses that issue because D addresses any person relating to the supply of narcotics. So the person here relates, and when we go back to the definition, relates to a natural and other person. But obviously, if a plane is in transit with Kenyan flag going through Uganda, Uganda has no business going into that plane because it offends the international rules. But as long as you enter the territory of Uganda, I think D would apply to you. It says any person. So even a company would be a person, a juridical person.
So, Honorable Nandara, I'm seeing D indeed would cover. Are you satisfied with that?
Mr. Chairman, if the Attorney General believes that the free zone is covered, then I have no problem.
Thank you. Honorable Minister, you okay with the proposed amendment?
Speaker, I'm okay.
Okay, thank you. I now put the question that clause 3 be substituted as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 4.
Chair. Switch on.
Clause 4 relates to penalty for possession of narcotic drugs and psychotropic substances. Clause 4 of the bill, the committee proposes that be amended. A, by substituting for subclause 2 the following. I quote, a person who commits an offense under subsection 1 is liable on conviction, A, in respect of a narcotic drug listed in second schedule, to a fine not exceeding 50,000 currency points or 3 times the market value of the drug, whichever is greater, or imprisonment not exceeding 20 years, or both. And B, in respect of a psychotropic substance listed in the first schedule, a fine not exceeding 25,000 currency points or 3 times the market value of the psychotropic substance, whichever is greater, or to an imprisonment not exceeding 15 years, or both. In subclause 3 in paragraph A, by substituting for the word section 28, the word section 27. Chair, the justification is to correct a mistake in cross-referencing the relevant provisions of the National Drug Policy and Authority Act. 2, to enhance the penalty for possessing a narcotic drug or psychotropic substance in order to make the provisions more deterrent. 3, in compliance with Section 37 of the Interpretation Act, to prescribe the maximum penalties that may be suffered by a person convicted under the Act. Chair.
Thank you. Chair, Committee on Health, you had issues on this?
Thank you very much, Chair. Clause 4, penalty for possession of narcotic drugs and psychotropic substances. Clause 4 of the bill is amended in subclause 3 by inserting immediately after paragraph B the following. A clinic officer or nurse with a certificate in specialist palliative care in possession of a narcotic drug or psychotropic substance for purpose of prescription or supply authorized under the National Drug Policy and Authority Act. The justification, Mr. Chairman, is to conform the bill to the National Drug Policy and Authority Act, under which the minister has made regulations authorizing a clinical officer or a nurse with a certificate in specialist palliative care to prescribe or supply certain narcotic and analgesic drugs.
Yeah, thank you. Now, I see Honorable Yume agrees with what the Committee on Defense proposed as amendment, and then he's adding on. Okay, just carry. Is not contesting. Honorable Honda.
Chair, I'm a bit uncomfortable when they talk about the market value, because it's like we are qualifying these drugs and we know the market value, yet this is done underhand. So within the law, how do we determine the market value of the drug?
Okay. Honorable Minister for Internal Affairs, how do you usually look at this and you say this? Because I always see it in papers that they've grabbed the drugs with the market value of this. How do you determine it? And yet there is no legal market for these products. Yeah. Is there an international standard? There. So I need it on record because I need someone to answer.
Right, Honorable Chair. The determination of the market price is normally dependent on what has been the dealing price, not the legally accepted, but the dealing price. So if they find if I arrest someone with drugs and that person gives evidence that I bought it for 10 shillings or 10,000 shillings, that's the value of that product.
Okay. Yes, but colleagues, this is an international standard. Everywhere in the world, when they arrest someone with drugs, they usually put the market value. Okay, and these investigators sometimes also they have underground people who go and help them to make research. Okay, so I think that shouldn't be a very big problem. I put the question that clause 4 be amended as proposed. Those in favor say aye and the contrary nay. The ayes have it.
Clause 5.
No.
Clause 4 as amended.
I put a question that clause 4 as amended stands part of the bill. Those in favor say aye and to the contrary nay. The ayes have it.
Clause 5.
Chair.
Thank you, Chair. Clause 5 deals with the penalty for trafficking in narcotic drugs and psychotropic substances. Clause 5 is amended by substituting paragraph A and B for A, I read, in respect of the narcotic drugs or psychotropic substances, a fine not exceeding 50,000 currency points or 3 times the market value of the narcotic drug or psychotropic substance, whichever is greater, or imprisonment for life or both. B, in respect of any substance other than a narcotic drug or psychotropic substance, which he or she represents or holds out to be a narcotic drug or psychotropic substance, a fine not exceeding 25,000 currency points, 2 imprisonment for a period not exceeding 20 years. Chair, the justification for this is for purposes of enhancing and prescribing the maximum punishment in compliance with Section 37 of the Interpretation Act. Chair, submit.
Honourable Minister, do you agree to the proposed amendment?
I concur with the proposed amendment.
Thank you. Honourable Jonathan Odur, then Honourable Komakei.
Thank you, Chair. I wanted to add, in addition to that, before the paragraph A, it should read commits an offense and is liable on conviction. So I wanted to add the word on conviction before paragraph A and B.
Attorney General? Okay.
No objection.
Thank you. Honorable Komakech.
Right, Honorable Chair. Many of these traffickers are actually also users. Prisoning them does not take the vice of using. So I was thinking, I was recommending that, would it be right that we also, on top of prisoning them, we subject them to treatment for a period of maybe 3 months, because that's the standard period of treatment in the prison, or after they are servicing, they go through rehabilitation center for 3 months.
Yeah, but we do have clauses in the bill that provide for treatment of prisoners. So when we reach that side, then we shall be able to address the concern. Yes, Honorable Gilbert Oranya.
Thank you, Chairman. Mr. Chairman, looking at the currency point in terms of fine, 50,000 currency point, if you multiply it times 20,000, it comes to 1 billion. Right, Mr. Chairman, I really feel that is too much. That is too much, right?
A drug dealer?
No.
That's pocket change, Honorable, you know.
Mr. Chairman, those one who want to participate in such kind of drugs, those are the people who own nothing. They are really not economically empowered. Therefore, if we put such high amount, Mr. Chairman, we are going to imprison everybody.
Thank you.
So I really feel, Mr. Chairman,
thank you. I now put a question that clause 5 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 5 as amended.
I now put a question that clause 5 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 6.
Chair.
Thank you, Chair. Clause 6 is about penalty for other acts connected to narcotic drugs and psychotropic substances. Clause 6, the committee proposes that be amended by A, substituting for subclause 1 the following. 1, subject to this act, a person who A, smokes, inhales, sniffs, chews, or otherwise uses any narcotic drug or psychotropic substances. B, without lawful and reasonable excuse is found in any house, room, or place where persons resort to for purposes of smoking, inhaling, sniffing, chewing, or in any way using a narcotic drug or psychotropic substance. C, being the owner, occupier, or concerned in the management of any premises, permits the premises to be used for 1, the preparation of narcotic drug or psychotropic substance for smoking or sale, or the smoking, inhaling, sniffing, chewing, or otherwise using any narcotic drug or psychotropic substance, or 2, the manufacture, production, sale, or distribution of any narcotic drug or psychotropic substance in contravention of this act, or D, has in his or her possession any pipe, tool, or other utensil for use in smoking, inhaling, sniffing, or administering in any other manner of using a narcotic drug or psychotropic substance, or any utensil used for preparation of any other narcotic drug or psychotropic substance for smoking, commits an offense and is liable on conviction to a fine not exceeding 50,000 currency points or imprisonment for a period not exceeding 10 years or both. Justification, Right Honorable Chair, is in compliance with Section 37 of the Interpretation Act to prescribe the maximum penalties that may be suffered by a person convicted for contravening the provisions of Clause 6 of the bill, and 2, to expand the provision to include all other narcotic drugs or psychotropic substances. I beg to move.
Thank you. Dr. Yume.
Thank you very much, Chair. The Committee on Health agrees with the proposals. However, it proposes the following amendments. Clause 6 is amended in subclause 1 by A, substituting for paragraph D the following: has in his or her possession any pipe, tool, or any other utensil for use in smoking, inhaling, sniffing, or administering, or in any other manner of using a narcotic drug or psychotropic substance, or any other utensil used for the preparation of a narcotic drug or psychotropic substance. B, inserting immediately after paragraph C the following: diverts a precursor for a narcotic drug or psychotropic substance under his or her possession for illicit manufacture or production of narcotic drug or psychotropic substance. The justification, Mr. Chairman: A, the deletion of the words "for smoking" appearing at the end of paragraph D is to generally restrict the possession of utensils used for the preparation of a narcotic drug or psychotropic substance without the authorization, rather than limit the restriction to when the utensil is used for smoking. B, the new insertion on precursor. In the interpretation section, we had introduced the word precursor. I had mentioned it's a building block for these narcotics. So B, the new insertion on precursor is to provide for control measures that will prevent diversion of precursors for narcotic drugs or psychotropic substances, as well as provide for control measures for the unchecked illicit production and manufacture of synthetic narcotics and psychotropic substances in laboratories. C, the insertion of precursor does not restrict access or possession of precursors by penalizes their diversion for illicit manufacture of narcotic and psychotropic substance. Thank you very much.
Thank you, Honorable Chair, Dr. Yume. Now, I have a situation, Honorable colleagues, where the Committee on Health, under the interpretation clause, had introduced some new words. One of them is precursor. And we have some clauses for which process we shall be attempting to look at how best we can control the precursors. So I'm trying to see how many there are, but I don't think there are very many. So when we reach on those clauses, we are going to stand over them until we agree to the interpretation of the word precursor. Otherwise, it would be, you might find we disagree with the interpretation, and then every clause would have passed. In that regard, would be void ab initio. Okay? Yeah. So please, I've guided on that. So let's stand on them. Sorry? We on 6, clause 6. Yes.
Mr. Chairman, I wanted the chair of the committee, not the one of health. You see, the moment you have introduced a figure, maybe if you remember.
Honorable Nanda, please, let us first get, I want us to discuss a clause in whole. Okay? I don't want you to submit on a clause, then we say let's stand over it. No, when we come back to that clause, you will make your submission on it. Otherwise, there is a very important, I read this bill, I read the reports from both committees. I know why I'm insisting on this, that we must first define precursor. Now let's stand over it, clause 6, we shall come back to it. Let's go to the next one. Procedure?
The procedures I'm raising. If in one clause, you have said 50,000 garage point, and you have put imprisonment not exceeding 20 years. In another clause, you're putting 50,000 garage point, not exceeding 10 years. Would it be procedure right to have different, the amount is right, the same, but when it comes to imprisonment, you are changing. He will be procedure right to move in that direction.
I will make my ruling once we reach on that clause. I already guided that we stand over it.
Clause 7.
Chair.
Thank you, Chair. Clause 7 concerns the provisions relating to certain prescriptions. Clause 7, the committee proposes that be amended. A, by inserting immediately after subclause 1, the following. A pharmacist shall not sell or supply a narcotic drug or psychotropic substance to any person except where the narcotic drug or psychotropic substances has been prescribed by a medical practitioner or dentist. B, in subclause 2B, by deleting the word to any animal. C, by substituting for subclause 3 the following. A person who contravenes this section commits an offense and is liable on conviction to a fine not exceeding 50,000 currency points or to imprisonment not exceeding 10 years or both. The justification for this, Right Honorable Chair and dear colleagues, is to expand the provision to include pharmacists since they sell and supply narcotic drug or psychotropic substances under prescription. 2, in compliance with Section 37 of the Interpretation Act, prescribe the maximum penalties that may be suffered by a person convicted for contravening provisions of the bill. I beg to submit.
Thank you. Dr. Yume and your team, and I want you to be clear, where you agree with the proposal of the committee, the proposed amendment, you tell us so that we know you're adding. Where you disagree, you also tell us so that we subject both proposals to debate.
Thank you very much, Mr. Chair. In Clause 7, the proposals by the Committee on Health, we proposed that in addition to subclause A, at the end, we add clinical officer or a nurse with a certificate in specialized palliative care. Therefore, it would read, a pharmacist shall not sell or supply a narcotic drug or psychotropic substance to any person except where the narcotic drug or psychotropic substance has been prescribed by a medical practitioner, a dentist, clinic officer, or a nurse with a certificate in specialist palliative care. The committee also proposed a new insertion. A clinic officer or a nurse with a certificate in specialist palliative care shall not prescribe or supply to any person a narcotic drug or psychotropic substance, except where the narcotic drug or psychotropic substance is required for palliative care. The committee also proposed another insertion that any other authorized person by the minister by statutory instrument to prescribe or supply a narcotic drug or psychotropic substance shall not A, prescribe or supply to any person a narcotic drug or psychotropic substance, or B, sign any prescription or order for the supply of a narcotic drug or psychotropic substance to any person, except where the narcotic drug or psychotropic substance is required or the medical treatment of that person, for the medical treatment of that person. The justification is to cater for the different categories of persons who can prescribe under the National Drug Policy and Authority Act.
Thank you. Chair, Committee on Defense. Yes, I will allow colleagues, don't mind. I just want to first get the view of the chair.
The views from the chairperson of Committee on Health, improvements. I have absolutely no qualms about it. I support them.
Thank you. Minister for Internal Affairs.
I do concur as well. Right.
Thank you. So, Honorable Tinka Simire, then Honorable Enos. I'm going to allow you, Honorable colleagues.
Thank you very much, Mr. Chairman. I have listened to the contributions by both chairpersons. I entirely agree with them. I would only want where they place somebody seeking these drugs from the pharmacist for purposes of doing research. Who gives him, because it is not provided for. And if we make such a law that purely does not allow any other person, particularly the researchers, not access these drugs, is inhibitive in terms of innovation, in terms of creativity, and in fostering research. I want to thank you. That's the clarification I want.
Yes. Chair or anyone from government side? Where are we providing for research, access by researchers, which is a very important.
Honorable Chair, can you just give us a minute to come back to you on it?
Okay, let's be picking other feeders as we get to that. I had allowed the Honorable Enos.
Thank you, Chair. I wanted to seek clarification from the Chair on Health Committee. Whether precursors and essential chemicals can be accessed by pharmacists. If yes, don't you think it's important we also add them in this clause that once they sell them, then there's a penalty that comes with that?
Yeah, but that's what he added in. He allowed in a pharmacist.
Whether the pharmacist can access the precursors, because here they are not mentioned. If then they have no access, then we can leave it. But if they have access to these controlled chemicals, what are the chances that they will sell them out, legally or illegally? So I wanted him to clarify on that.
Chair?
Thank you very much, Mr. Chairman. You had guided we stand over precursors for us to be able to appreciate it in the interpretation. But with your guidance, Mr. Chairman, I can still.
For this clarification, I think it's okay. No, please, let's allow a member to first finish. I'm going to give you a chance whenever correct.
Mr. Chairman, in clause 6, we had made a provision where we inserted precursors, and it reads as follows: divert a precursor of a narcotic drug or psychotropic substance under his or her possession for illicit manufacture or production of a narcotic drug or psychotropic substance. Mr. Chairman and colleagues, the bill does not seek to criminalize access or possession of precursors. What it seeks to criminalize is diversion. For example, if you import benzene for laboratories in schools, then you divert it to make narcotics. That's where the bill applies. I mean, what we are proposing should apply. Thank you.
Thank you. Now, colleagues, in one of the interactions yesterday, this issue was seriously raised by the team from the National Government and Lit Collab. And of course, even some of us were concerned because like us from rural areas, if our schools cannot access, what will happen? So, but it was clearly put under this bill, they will access. The problem is if you divert, because someone can say, but I accessed illegally if you don't provide for diversion. Okay, so the issue is just on diversion. But in terms of access, they will be okay as they've been accessing. Dr. Boka then Nandala.
Yeah, thank you, Chair.
I come here.
Providing information on the use of psychotropic substances and narcotics for research purposes. Before any research is approved, the individual or institution doing research has to seek for clearance from institutional review boards. And therefore, that matter, we may have to have an inclusion of institutional review boards cater for the use of narcotics and psychotropic substances for research purposes. I thank you.
Attorney General, you had got a response to that issue of research? Switch on.
Yes, thank you very much, Right Honorable Chair. Right Honorable Chair, in this bill, everywhere you find for medical purpose, it means the use of a narcotic drug or psychotropic substance for treatment or research that is provided by a medical practitioner, dentist, pharmacist, veterinarian, while acting in the usual course of his professional practice and in accordance with the standards of care generally recognized and accepted within the respective profession. So every time you find the word for medical purposes, it also includes research. So if a person is found with psychotropic substances and it is said that he holds them for medical purposes, it also includes research. And the aspect you raise is also addressed there because there are standards, different standards in different places. Research in university, in medical areas, research is different. So we require you to hold it to those standards. So I think that's where we address it, Right Honorable Chair.
Thank you. Still on the Honorable Nanda, is yours different? Because I wanted to handle the issue of research and we finish it. Yeah. Chair. Let's conclude it. I don't want it told us when I was I'm going to
Land Attorney General is saying wherever there is the concept medical, it implies research. Medical purposes may include, because I was looking at a sociologist doing research on this particular, so would that cater, if that caters for a sociologist who is interested? Yes, because he's looking at the impact.
So he wants to test.
Yes. So I want to be sure if it is included, I will have no problem. Thank you.
Okay, Attorney General.
Thank you very much, Honorable colleague. I think the definition says having a narcotic drug or psychotropic substance for treatment. That's one. Or research. It's not only for medical research. That is why we put up the issue of standards within the respective profession. So different professions have different standards for which they use for their research.
Thank you. So Honorable Mshemeza, you can access for social research purposes. I had allowed, is it on research? Is it on research? If it's on research, let's conclude the one of research. Honorable Dur.
Chair, under clause 4, we had already passed a provision, and subsection 3 actually reads that a person who has possession of narcotic drug or psychotropic substance under a license issued under section 28 of the NDA Act, permitting him or her to have possession of the narcotic drug. So I thought that that takes care.
It would cover it.
Cover
Yeah,
that.
thank you. That's thank you for further clarification. So, Honorable Nandara, research is on.
Mr. Chairman, one, I would love also to get clarification from the chair. If this medical and dentists, they have houses, there will be trade shops are like housing. Are they going to be gazetted as these ones are specifically allowed to hold such drugs? That's number one. Number two, Mr. Chairman, we passed clause 4, where we talked about 50,000 carriage point and 20 years. Now here we're seeing the chair bringing 50,000 carriage point and 10 years. Wouldn't it be right that the chair agrees for purposes of the law flowing very well, that this one instead of 10 also put 20 years as we put in clause 4?
I know the law on equivalence of currency points to penalties was repealed, but consistency wouldn't it be very important for consistency purposes? Attorney General?
Actually, that was my major concern, because we amended that law in 2023. The Law Revision Miscellaneous Amendments Act 2023. And I hope that Attorney General has had occasion to look at the proposed fines and imprisonment terms to comply with that particular law.
Attorney General?
Thank you very much, Mr. Honorable Chair, Right Honorable Chair. First of all, Right Honorable Chair, the law revision law that is variously cited here was trying to bring the old, very old provisions in old laws into some form of semblance up till 2017. I would not want to stand here and say that there is a law in this country which fetters the power of Parliament under Article 79 to prescribe a penalty. So it is not about equivalence, it is about what Parliament prescribes at that time. Secondly, Right Honorable Chair, the penalty on fines and monies is deterrence on the business side. The penalty on incarceration is penal. So when you look at the offenses, some offenses which are for trafficking, they carry a higher penalty of imprisonment. Whereas the offense of killing yourself by smoking these substances may carry a lesser penalty. So Right Honorable Chair and members, I think unless Parliament decides that it would like to change the particular penalty prescribed in any particular provision, there is no law in this country which requires 1 currency point to be equal to 1 day in prison or anything else like that. I beg to
Okay, thank you. Honorable Chair, Honorable Nandara raised an issue.
Thank you very much, Chair. This law should not be read in the proposed law. In isolation, we have the National Drug Policy and Authority Act, which caters for the different classes of drugs and to be held under which circumstances and by which cadres of people in the medical profession. So that is catered for there.
Thank you. Honorable Santa? Yes, just let's conclude this.
Yeah, Mr. Chairman, yes, you're right. We are saying here in this law, we're dealing with these bad drugs. National Drug Authority, according to even the Attorney General said, 2017, all laws, now we have discovered how bad it is. Would we go with the National Drug Authority, which was made many years with simple penalties, comparing to what this one is causing? In fact, what I'm trying to raise, Mr. Chairman, is that here, the chair of the committee proposed that it is 50 current points. We agreed. And not exceeding 20 years. We agreed. Why is it here saying again 50 current point and putting less years instead of matching it with the other one? Yes, that's why we want just consistency, Mr. Chairman. Only.
I think what I pick from Honorable Nandara is saying we should be consistent. But the Attorney General was saying for each crime, okay, we should assess it independently of the other. That's what I picked from him, saying we don't do a blanket to say this one, if we charge you 1 billion, imprisonment should also be 10 years. He's saying some of them, the economic side might be the same, but the penal side can be different depending on what we want to deter and the impact of that crime on community. Okay, so it's a balance. It's a balance which I'll put you, honorable colleagues in the house. I don't want us really to focus on that so much. It's a balance we can strike here. Yeah, but Honorable Santa Room had a different issue.
Yeah, Chair, thank you very much. Mine is quite different from this, but Chair, I want clarification from the chairman of the committee.
Which committee?
Of the Committee on Internal Affairs. He's suggesting that we delete the word substance, we delete the word animal. And Honorable Chair, we have just talked about research. And some of this research, when they are doing the trials, the medical research, they normally start from the animals. So if we delete the word animal, would it be doing justice to this bill as far as research is concerned? Thank you.
Thank you. On the same, Jonathan? Honorable colleagues, if I call you just your name, you know automatically I added honorable.
Yes, Chair, I had the same concern on the proposal to delete the word to any animal, but in a different perspective from what Honorable Santa has raised. The spirit of this is that there is need to regulate how medical practitioners and veterinary surgeons prescribe, because somebody can prescribe for use in treating an animal when actually the purpose is different. So when you read the spirit of clause 7, 1 and 2, they carry the same spirit, except that under 1, it is for medical and dental practitioners. Then under 2 is veterinary. So when you delete the word animal and you leave it hanging, then this law then is a bit defective. So I don't know whether we can add to a person here, because the person would then go and treat animals. So I propose that we replace the word to any animal, we replace it with to any person.
Thank you. Chair, you agree to that?
Chair, I agree to the proposed amendment because it improves proposal on the offense. Thank you.
Thank you, honorable colleagues. I put a question that clause 7 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 7 as amended.
I put the question that clause 7 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 8.
Chair.
Chair, clause 8 is about remove of a name from register. Clause 8, the committee proposes that be amended by inserting immediately after the word dentist, wherever the word appears in the provision, the word pharmacist. The justification is to expand the provision to include pharmacists, since they sell and supply narcotic drugs or psychotropic substances under prescription. Chair, I submit.
Honourable Minister.
That's a reinforcing substitution, and I agree.
Thank you. Yes, Honourable Nambeshe.
Mr. Chairman, this clause does not give any breathing space for an appeal, because upon a successful appeal against the conviction, there should be a reinstatement, even when the particular medical practitioner has been deregistered. So I would propose an amendment, Mr. Chairman, that you provide for reinstatement of the medical practitioner upon a successful appeal against the conviction.
Attorney General.
Thank you very much, Lop. Lop makes, I think the point is the same here, but I think maybe we could draft it just for clarity, because we are saying if there's a conviction. So if the conviction is lifted, then the person is, so there's no conviction. So we can go back and look at drafting, but I thought that the meaning was the same, where a medical practitioner is convicted of an offense under this act, he or she shall notwithstanding any be liable to have his name. It is not saying his name will be removed, will be liable. So there's a process you have to go through. But I don't know, we can add that upon lifting of the conviction can be returned on the register.
Really, I think this is very clear. Because when we are going to add on all that, then it's going to be too wide, and even the drafting, because you no longer have a conviction, you served it and you're done. So it's just during that process of conviction, when but once you serve it, you're no longer convicted. So we don't need to really repeat it.
Thank you. I have seen in clause 8 the removal of name from the register. It includes medical practitioner, dentist, and veterinary surgeon. But earlier on, we had talked about the researcher. Is it possible to include researcher there? Because even a researcher can abuse.
Do we have a professional body for researchers, to say you have a license for researching? No, researcher wouldn't apply here. Here, these are professional. It's looking at professionals. Okay. At any time, you can be a researcher, even when you're a pharmacist, even when you might know.
Chair, this research is like restricted only to the medical research. But there could be other professions that are doing research on similar things, like Professor Shevers has said.
But that's what was clarified under 4.
Yes.
Yeah, that's what was clarified. No, let us sort out the issue of research. I want a member to be satisfied. Anyone who can help me on that, who can submit on that of research? Chair.
Thank you, Chair. Professional bodies like engineers, lawyers, pharmacists, medical practitioners have bodies that regulate them. For that case, they are registered. Now, when an offense, when you are undergoing a trial of this magnitude, one of the measures is that your name is struck off the register. This is what we're talking about. But a researcher, researchers per se are not registered in any of the, you can be made, if you are a medical researcher, then you are under the medical professional medical board, practitioners board. If you are a legal researcher, you are under the law council. If you are an engineer, so researcher per se is not applicable.
On this, please don't access a microphone without my permission. I thought those habits had stopped. Yeah. So on research is on the same point. Let us first finish this point raised by Honorable Songa.
Thank you.
Yes, Dr. Runme.
Thank you very much, Mr. Chairman. I don't think that it would be prudent of us to restrict research to the educated to do the research, those in the medical or in the legal research and so on. Even the local people can do research. So where are they going to be captured? And where are they not going to be captured by this law when they are doing their local research? We are seeing a lot of people doing herbal research. And those herbal researchers get qualified. Until they get qualified, they are still using colloquial methods of research. How are they going to be captured? They are not culpable. Thank you very much, Mr. Chairman.
Yeah, thank you very much. In Uganda, if you are to conduct medical research, then you need to be approved by the Medical Research Council, and we passed a law in this house some years back, or the National Council for Science and Technology. So there are those two bodies which must authorize you to proceed with research. So we could make reference that the researcher, because if you are researching on these kind of substances, they are medical in a way. So we could make reference to those bodies which gives you authorization to carry out research, so that people don't just come out as researchers and then they abuse these substances. They should be having that authority from those bodies, which are established by law.
But that's complicating thing. Honorable Kaduchu? Now the doctors, I don't know who will treat me among the two.
Thank you so much. Just adding value to the issue of research. Normally there is a research protocol, and the protocol has to go through various stages of approval. And in that protocol, they are monitoring values of any advanced deviation. And it is the National Council for Science and Technology that approves that research protocol or proposal. So in a way that if there is any deviation, anything that in terms of advanced monitoring and reporting has deviated from the research protocol, then it is captured. So I think researcher really does not belong to the professional body as stated, because the professional bodies are having regulators under their council. So those are really the professional body, like the medical, dental, and the other professional under their mother council. That is my take.
Now, honorable colleagues, please, I want us to refocus. The clause is on removal of name from register. We don't have a register of researchers. Period. We don't have it. So now how do you want to remove someone from where it doesn't exist? Honorable Jonathan, you no, but on this.
Chair, professionals have a higher duty of care, and therefore they are held by a different standard. This provision is to impose additional punishment to the profession. It doesn't exonerate them, any other person, from being convicted under a different section. So if a researcher has messed up, the provisions in different clauses can still deal with that person, except that this one, because they are professionals with a higher duty of care and standard, they are being held and said, we need to punish you because you are careless in executing. So we shall remove you from the register.
Sure, that's it. Simply put, okay? This is removal from professional register of medical, of legal, of, but as historians, we don't have professional bodies of historians. So for us, we are exempted from all these problems. But Attorney General, I will allow you on a vision.
But honorable colleagues, I think what we are saying as members of parliament, that we don't expect lawyers to to be doing research on cannabis. The people we are anticipating who will be doing research on cannabis are these professionals. But for those others who are doing research, we have the Complementary and Traditional Medicine Act. They have their protocols that they follow there. But like the chair said, remove the name of that person so he doesn't continue doing it, but only the profession.
Thank you. Still on research on Mshemezi. Then on Aisha, still on the
Thank you so much,
research
Chair.
is closed. Yeah. On
Thank
research is
you.
closed. Yeah.
Thank you, Chair. I would love to understand the bearing of this clause, removal of name from register. We have had a clause on possession, penalty on possession. We have had a clause, penalty on trafficking. We have had a clause, penalty on other acts connected. I now want to understand the bearing of this. If a doctor, because if it's under possession, just possession, there's a penalty for it. If it's traffic is a penalty for it, because right, Honorable Chair, we have seen circumstances where there have been abuse of either laws or powers. Suppose someone simply carried a box of this drug and put it in someone's clinic and is unable to, there's a situation where you're unable actually to defend yourself when you're right. You're going to have this person deregistered, meaning he's not going to practice anymore. Are these other penalties on possession, on trafficking, on other connected activities like smoking and use not enough to cover all those? I want to understand the bearing of this specific that would cause someone to lose his whole life of education.
Thank you. Attorney General, is it related? Okay, Honorable Mshemeza.
Thank you, Chairman. There is an issue I was not satisfied. A clarification was made that if you serve your sentence after conviction, there is no conviction. And there is an assumption that you'll be restated, you'll be restated. Am I right?
Mm-hmm.
Now, I'm relating to what is in our electoral laws. There is a provision where you are convicted of an offense, you serve your term, and then you are barred 10 years to stand again. Why are we assuming that after serving your conviction, and there's no conviction, that you will be restated? I need that clarification when you relate with our electoral laws.
Yeah, but Honorable, you yourself, you have answered that it is specific, it is provided for. But on top of conviction, you will again be barred for 10 years. It's provided for. And here it's not.
I think, Honorable Aisha, the issue raised was very well articulated by Honorable Dur. Here is a standard of care expected of these specialist persons, dentists, medical practitioners, pharmacists. They are specialized persons whom we hold at a much higher standard, that if they find another person taking this substance, it may not amount to deletion from the register in their profession. Say he's an engineer, maybe a lawyer or something. But for a doctor, we are saying that a doctor who does that is another punishment. So yes, the other, they could be convicted, sent to prison, and on top of that, removed from the register. It's just a higher standard that is expected of them. So here we are saying, we are moving to Parliament and saying, Parliament, we are asking Parliament to pass a law which tells a doctor or a dental practitioner that in the course of your ordinary duty, you are likely to get in contact with narcotic and psychotropic substances. If you misuse them, we could fine you, imprison you, and even deregister you. But we are saying to the lawyer that you, if we find you with this substance, we may imprison you and fine you, but not deregister. That's all we are saying. So we are asking Parliament to agree with us.
I now put the question that clause 8 be amended as proposed. Those in favor say unto the contrary nay. The ayes have it.
Clause 8 as amended.
I now put the question that clause 8 as amended stands part of the bill. Those in favor say unto the contrary nay. Ayes have it.
Clause 9.
Chair.
Thank you, Chair. Clause 9 concerns penalty for receiving additional narcotic drug, psychotropic substances, or prescription without disclosure of earlier receipt. Clause 9, the committee proposes that there should be substituted the following: penalty for receiving additional narcotic drugs, psychotropic substances, or prescription without disclosure of an earlier receipt. 1, a person who, in the course of treatment of a physical, dental, or mental disease, or an owner or caretaker of an animal, is supplied with or receives a prescription of a narcotic drug or psychotropic substance by a medical practitioner, pharmacist, dentist, veterinary surgeon, shall disclose that fact before he or she is supplied with or receives a prescription of an additional narcotic drug or psychotropic substance. 2, a person who fails to disclose the fact under subsection 1 to a medical practitioner, pharmacist, dentist, veterinary surgeon, as the case may be, and is supplied with or receives a prescription of a narcotic drug or psychotropic substance, commits an offense and is liable on conviction to a fine not exceeding 20,000 currency points or to imprisonment for a period not exceeding 10 years or both. Right Honorable Chair, justification for this is for clarity and better drafting. 2, to expand the provision to include pharmacists, since they sell and supply narcotic drug or psychotropic substances under prescription. 3, in compliance with Section 37 of the Interpretation Act, to prescribe the maximum penalties that may be suffered by a person convicted for contravening the provisions of the bill. Right Honorable Chair, I submit.
Thank you. Honorable Minister.
I concur, Right Honorable Speaker.
Thank you. Yes, Honorable Nwagaba.
Yeah, thank you, Honorable Chair. Actually, the draftsman had done a poor job. You've done a good job. But I thought you would add the word additional in the sub-clause 2 for emphatic purposes and to capture the spirit of the original draftsman. Where you say a person who fails to disclose and is supplied with or receives an additional prescription. I thought it would be important. Yeah.
Yeah, I think that is in line with objective and principle. So I put a question that clause 9 be amended as proposed. Yes, Honorable Enos.
Thank you so much, Chair. On that clause, I was seeking clarification from the Attorney General, whether it's not important also to specify the records required for these transactions, records that need to be kept by these pharmacists for the sales made to relating to these narcotics.
I don't think it would serve us well, because as you know, today we are using EFRIS, and tomorrow it may be something else. So if you prescribe a record, a particular kind of record in a statute, such as this one, you're likely to run out of steam so fast. But we know that if you have a substance, if it's a prescription, there's a note. If you paid for it, there's a receipt, there's an invoice. So they will change. I don't think it will serve us well.
Explain it further. When you look at this particular clause, it applies to the recipient, not the person doing the prescription. So you don't need that record.
Thank you. I now put the question that clause 9 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 9 as amended.
I put a question that clause 9 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 10.
Chair.
Right Honorable Chair, clause 10 is about supply of toxic chemical inhalants to young persons. This one. I repeat, clause 10 concerns the supply of toxic chemical inhalants to young persons. For clause 10, Right Honorable Chair and Honorable colleagues, there is substituted the following. 10. Supply of narcotic drugs or psychotropic substances to a child. A medical practitioner, pharmacist, dentist, or any other person who supplies or administers a narcotic drug or psychotropic substances to a child where the narcotic drug or psychotropic substance is not required in treatment of a child commits an offense and is liable on conviction to a fine not exceeding 50,000 currency points or to imprisonment for life or both. Right Honorable Chair and dear colleagues, the justification for this is to enhance the penalty for supplying narcotic drug or psychotropic substances to a child in order to make the provision deterrent. 2, to restrict the provision to the subject matter of the bill, since intoxicating substances are alien to the bill and are incapable of examination. 3, to require the supply and administering of narcotic drug or psychotropic substances to a child to be for medical purposes. 4, in compliance with Section 37 of the Interpretation Act, to prescribe the maximum penalties that may be suffered by a person convicted for contravening the provisions of the bill. Right Honorable Chair, I submit.
Thank you. Honorable Minister. When I say minister, you agree on your side.
Thank you very much, Right Honorable Chair. Right Honorable Chair, we're proposing that we add the medical practitioner or person who knowingly, because there is a person doing something in good faith in the course of his employment, maybe he's been misled with, but there is no criminal intent and is practicing. So I wanted to add who knowingly supplies.
Okay. Dr. Rulme.
Mr. Chairman, the phraseology should include any person as it was in the principal bill. Why? Because if you restrict it to the professionals as mentioned, you are taking away individuals. It can be a mother or a father who is not a medical professional, who is administering the same to a child. It is possible.
I think that's the matter, honorable colleagues. Okay. Attorney General, would that be?
Thank you very much, Right Honorable Member. I appreciate it.
Thank you. Honorable colleagues, I put a question that clause 10 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 10 as amended.
I put a question that clause 10 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 11.
And now, honorable colleagues, the public gallery this afternoon, we have pupils and teachers of St. John and Ruumu Primary School, Kitgum District. They are represented by Honorable Nekalit Dennis Amere and Honorable Bear Lillian. They've come to observe proceedings of the House. Join me in welcoming them. Kindly stand up so that we can welcome you, our beautiful, guests. Thank you. Honorable members, furthermore, in the public gallery this afternoon, we have a delegation of youth leaders from Bukwenjo West constituency, Bukwenjo District, led by Mr. Muyambi Jr. And they are represented by Honorable Ephraim Biralo and Honorable Oliver Katwes de Koyechenga. They've come to observe proceedings of the House. Please join me in welcoming them. Thank you.
Clause 11.
Chair.
Right Honorable Chair, clause 11 is about penalty for cultivation of certain plants. For clause 11, the committee proposes that there be substituted the following. 11, penalty for cultivation of prohibited plants. 1, the minister responsible for health may issue a license to cultivate or gather a prohibited plant. 2, a person shall not cultivate or gather a prohibited plant without a license issued by the minister responsible for health. 3, a minister may issue a license subject to conditions as the minister may consider necessary. 4, a person who A, cultivates a prohibited plant without a license, or being the owner, occupier, or manager of premises, permits the premises to be used for the cultivation, gathering, or production of a prohibited plant, commits an offense, and is liable on conviction to a fine not exceeding 120 currency points, or 3 times the market value of the prohibited plant, whichever is greater, or to an imprisonment for a period not exceeding 5 years, or both, and in case of a second subsequent offender, to imprisonment for life. Justification, Right Honorable Chair, is to require the cultivation of prohibited plants to be authorized by license and not mere consent of a minister. 2, to harmonize the provision with Schedule 4 of the bill, which prescribes prohibited plants. 3, in compliance with Section 37 of the Interpretation Act, to prescribe the maximum penalties that may be suffered by a person convicted for contravening the provisions of the bill. I submit.
Thank you. Committee on Health, you had an issue with that?
Thank you very much, Mr. Chairman. The Committee of Health agrees with the proposals by the chairperson, but however recommends a new subclause to be inserted before subclause 4. And it reads, the minister shall make regulations providing for procedures and conditions to be fulfilled for license to be granted under subsection 1 of this act for the cultivation of prohibited plants. The justification is to empower the Minister of Health to make regulations providing for the procedures to be fulfilled for the grant of license to cultivate prohibited plants.
Yes. Yes, Honorable Chivumbi, I'm going to pick you, Honorable, colleagues, to get your views.
Chair, Chair, this is a clause that is very tricky. And it's where Parliament needs to be sober. We are always sober while enacting this provision. Because essentially it is a provision that is going to allow some people to be permitted to grow even marijuana and other plants. Therefore, we need to be extremely careful. But I have an issue. There are, at present, people who have been growing, for example, Mira. And as of now, up to now, Mira has not been a prohibited plant. And people have their own gardens. Now, this provision, drafted the way it is drafted, seems to take care of only people who are intending to grow from the day this act is enacted. I just have a feeling we need a hybrid that do not criminalize those that have been found growing it, of course, I'm being careful. Other cannabis and all the other crops are prohibited by law. It's only Mira that has a small room which is not being prohibited. Therefore, the care I would like to appeal to the House is not to amend the law. I mean to have enact a law that on day one criminalizes a particular section of the population without giving them a transit period. I'm very keen.
Yeah.
I'm very keen that section 89 of the other law, subsection G, would literally empowered the minister to come up with that provision. So the care I want to ask the committee and the minister is that my people and the rest of actually, Butamba doesn't have the highest number of Mira growers. Wachiso has more, Maracha has more than Butambala. So it is not to be restricted as if it is a Butambala issue, not at all. That's not the issue. So the care I want to this law is to ensure that on day one, it does not criminalize people who have been found growing it because it has not been prohibited plant. And my reading of this provision is that from the day, and if we agree with section 1 which we passed, that means it comes into force on the day of accent. So I would beg the indulgence of this parliament that it must take care of that huge population.
Thank you. Now, honorable colleagues, I don't want us to panic over this. Okay? Because the crops that are going to be prohibited are in the schedule, which we have not yet reached. That's number one. So we cannot do in anticipation because we don't know what is going to be prohibited. But number two, every law has transitional clauses. Okay? So in case we reach that side, we shall have to ensure that when we are processing transitional clauses, all these aspects are provided for. Otherwise, now it would be a premature debate, not knowing whether the prohibited or controlled crops are going to be approved under the schedule or even under the transitional clause will be allowed. That's what I would want to add. Honorable Jonathan, you wanted to add something to that?
Chair, in principle, I have an issue with the wording. By every literature available, once you use the word prohibited, it means under no circumstance that a crop can be grown. So I wanted the Attorney General and the Minister to first address us on that. The moment you say prohibited plant, it means neither the Minister nor anybody can then later on say that it is allowed. Either we use a word
you can propose
different,
we can say
prohibited, maybe restricted,
or restricted
plant, so that when we go to the shadow, we shall mention it that way, meaning that the handling is actually restricted but not prohibited.
Sure. Honorable Attorney General, you wanted to comment on that? Yeah. And the word prohibited?
I think if we use restricted, that's temporary. The prohibited is like if you went to the airport and they said cameras prohibited, it doesn't mean everyone there doesn't have a camera. Some people have them. So my worry is the intention of this law is actually to prohibit. So the first thing is prohibit. So everyone, when you come, you are prohibited. The other one is an exception. If it doesn't really hurt much, honorable colleagues, I don't think there will be any contradiction if we left it like that, because we are communicating something to the population that this in Uganda is prohibited. That is the principle. And then, but if you wanted to use the word restriction, I think it will create it will lessen. Yeah.
Shadow Attorney General. No, now we've gone into issues of the law, not general interpretation.
Thank you, Right Honourable Speaker. Let me begin with the issue I had on.
Why can't you first help us
Okay.
on this? Yes.
This particular one, I agree with the framers of the bill. The word prohibition should be maintained. What will be in dispute is what are those plants that will be prohibited. But I wanted to also have an issue with
So Honorable Jonathan Odul is asking that when you prohibit, can you still have exceptions? Exemption?
Yes, the law can prohibit and provide for exceptions.
Yeah.
On the same law.
Okay.
Only that what you prohibit, you don't allow, but you can bring exceptions. So my issue is with clause 4 for the proposed amendment, clause 11(4)(b) seems to create strict liability, particularly for landowners. And I know, right, Honorable Speaker, you are among the biggest landowners. Some of these plants.
I want it to go on record that unless you lay on table evidence that I'm not a man.
Withdraw that. But there are some of these plants which grow naturally. And even without your knowledge, you are feeling this because of cross-pollination and the like. So I would propose that we put the word knowingly.
Yeah.
Knowingly permits. Otherwise, you will find convicting, including the Honorable Minister next to you, when marijuana has just been in his farm unknown to him.
I totally agree. A strict liability clause on such issues, it would cause very big problems. Honorable Fidra.
Yes, thank you, Chair. Mine was related to what the Shadow Minister had said, but in some parts of this country, some of these prohibited to be plants grow wildly, and we collect them. So my proposal was if we can, under, is it clause number 4, a person who cultivates a prohibited plant without a license. B would be a person who gathers the prohibited plants from the wild for this purpose. And certainly maybe B just who gathers these plants, because indeed they grow wildly. So how do we cater for it in the bill?
Honorable Attorney General, on that.
I don't know, Honorable Fidra, whether B answers your question. A person who, being the owner, occupier, manager of premises, knowingly permits the premises to be used for cultivation, gathering, or production of a prohibited plant. I don't know whether that addresses your question.
Chair, in parts of this country, these plants are growing wildly, naturally. And here we are coming up with a bill that we want the minister to prescribe the cultivation of these prohibited plants. On the other side, if they grow wildly, we even equally do not want its gathering for the purpose of the consumption. The other second bit of it is Ugandans are a little bit good. In some parts of this country, in the forest deep, they even intentional would go and grow them, and with the assumption that it grows wildly. So all this, I was thinking that maybe
Attorney General,
we should.
You want to comment again on the same?
Yes, thank you very much. I think I propose that we rephrase 4A to read a person who cultivates or gathers.
Who knowingly.
No, that is the knowingly is in the second one for the use of the premises.
Okay. Yeah.
A person who cultivates or gathers a prohibited plant without a license. Thank you.
Okay. Thank you. Honorable Enos.
Thank you, Chair. I'm looking at a scenario. For example, where I come from in the Antonde, farmers have been growing marijuana for medicinal purposes, specifically for cows and health purposes, on less than an acre. These farmers have been doing it. With this law, it implies that we are going to license bigger companies to come and manufacture marijuana for medicinal purposes and export it. And that means we are putting out this person, 1 acre person, out of this business of medicine. My question to the wait, okay, I could have brought it wrongly, but My argument is this: if we pass it the way it is, we are going to criminalize growing marijuana for medicine on a small acreage, knowing or unknowing, as he has said, but then we license bigger companies to do it. My question to the team on the front bench: how best can we do it? How best can we protect this person who has been doing it for the last several years of our lives, for cows, for their families, without selling?
Even personal consumption without selling.
I'm consulting. Yes. Okay. I'm consulting the team on the front bench. How are we providing for these people?
Attorney General.
Thank you very much, Honorable Enoch.
Or if you have issues related to that, you can raise all of them, then he answers at one. Honorable Katoto, was it related to the same? To Honorable Enos's?
Yes, right, Honorable.
Okay.
It was related to Honorable Enos's.
Yeah.
I have about 3 or 4 sticks in my banana
Please
plantation.
take your seat, Honorable colleagues.
I have its own.
Now I'm going to know who are the growers. So by the time we finish.
Chair, I have only about 3 or 4 plants in my banana plantation, specifically for my cows and goats and the chicken.
So you're knowing they're growing?
Yes.
Okay.
Yes. Thank you, Chair.
Hey.
Right, Honorable.
Some people access without
and colleagues.
Some people access without permission, it seems.
In my constituency, the whole mountain has those trees. They are there since, and they were 9 years ago. They pick them here, the Somalis hit very much. I'm told in the bush they go and take there. In fact, it's a foreign currency. Now I don't know what to do. Do we go and cut the whole forest of a big mountain, or what do we do?
Honorable Minister, we haven't reached that part of a list of prohibited plants. Once we reach it, you will be answered. Colleagues, Honorable Batua, Honorable Ranya.
Thank you, Honorable Chair. I'm the Shadow Minister of Health, and I wanted to bring to the mind of the Attorney General that perhaps the views coming from colleagues regarding these herbs, since they don't give the effect to the same extent, some are culturally attached to the community, as people are claiming they have them for their animals and all that. How will it be if we introduce the word that is used in other legislations similar to these ones, like the one for NDA? They use the word controlled. They talk of controlled drugs. These are drugs that you really need to get permission or, clearance from the minister or from the authority time to time. So can we create a cluster of the controlled herbs and the prohibited herbs such that we can take care of the views that colleagues are bringing on table?
Yeah, but you see, honorable colleagues, when we are handling the law here, we look at the intention of the new law. Now, if you have the copy of the bill, it talks of defects in the existing law, and it's listing the weaknesses of the NDA law. And that's what it's trying to cure. Okay? So now we cannot again then we shall be diverting from the principle and objective of the bill. So then, honorable colleagues, because I know when we go on the schedule is when we would address this issue properly. So I'll pick Honorable Viraro. Oh, I had picked Honorable Gilbert Oranya. Yes. Then Honorable Viraro.
Thank you, Mr. Chairman. Mr. Chairman, on this, we need to be very serious. Right now, Mr. Chairman, for example, in my constituency, there's somebody who went and hired the land from the farmer, and the person is growing opium. From this bill, you are saying the person who gave the land knowingly, somebody went and hired my land. For me, I have no control over him who was already hired my land, and the person is growing opium in my land. Do I also stand liable
Thank you, Right Honorable Speaker. Like many of my colleagues have highlighted, it is a fact that in our communities, especially all people who have got domestic animals, cows, goats, sheep, pigs, and even chicken, they use this plant as a drug against these other coccidiosis and the rest of it. Partly also, we grow them in the pots as flowers. In our places in my village, if I go to Shikamba, LC1, you'll find a number of people with 1 or 2, 3 bushes. So as we register, it is for animals. It is part and parcel of a herder's life. Currently, it is part and parcel of any herder's life.
Okay.
And repellent even for mosquitoes. So as we register, Speaker, we need to know these facts within us.
Thank you.
So that we move on.
Now, honorable colleagues, you go in a village, okay? Because we have, some of us come from deep villages. You find a youth who has never even stepped in any town. Let's assume my village deep in Bitereko. A youth has never stepped in Ishaka, which is a modern town, or Kunjiri town near us. But you find youth who are now, colleagues, if you've not had a person, let me tell you this. If you have not had a person, a drug addict in your family, and you know what it means, you will continue joking. But if it has happened to you, or you have a drug addict who has raped a person in your area, that's when you will understand what it means. I stop there. Honorable Jonathan, you wanted to guide on that?
Yes, I wanted to find out from the chair and the ministers, when you speak of alliances, it is supposed there are certain procedures. And if you go the labor export licenses, you advertise, there is a public hearing, there is a mechanisms for appeal, and etc. So to ensure that every applicant is given a fair opportunity, if at all it is open that people can apply to grow, whether for domestic or for animals, for what purpose. If you retain this provision as it is, what are the safety nets for the grant of alliances? Because once you speak of alliances, you are not speaking of any other document. That's the concern I have here.
Thank you.
Otherwise, I wanted to propose that we stand over it so that we address the issue of the licensing regime and the procedures to be clear for this purpose. Otherwise, some people will be excluded and then they have no redress for appeal.
Thank you. And that's a very serious issue because, for example, now you already have some who have a license and others cannot get it. So how are we going to ensure that it's not for a chosen few, a chosen few, and it becomes for dealers and Abrams?
Thank you, Mr. Chairman. Mr. Chairman, while I agree with Honorable Odur, I thought we need to reflect on the question of income and the big numbers. I was of the view that this idea of saying there will be big companies that will come to grow, is indeed possible to register those who are already involved in the growing. We know the quantities, the numbers, and ensure that the factory that is going to produce drugs out of these psychotropic substances specifically buy from Ugandan growers.
Okay, thank you.
Thank you.
Yes, I had picked Bataringaya. I'm going to pick you, colleagues, please. And let's do 1 minute each, quick.
Thank you, Right Honorable Speaker, Chairman. The whole cattle corridor, I'm very sure, has some plants for animals. The cattle corridor. Now we have also picked up keeping other animals other than cattle, sheep, goats, and the other ones, and chicken. No, not pigs. Extremely outside the cattle areas. How will these cattle areas who have traditionally accessed this for the drugs of their cattle, how will they access this substance?
Thank you.
The Chair, the Attorney General had alluded that we add the word knowingly only on 11.2b, but I was of the proposal that we include the word knowingly also on 11.1, where we say no person shall knowingly cultivate any prohibited plant, because not everybody knows actually which of these plants are actually prohibited. And we have already ascertained it that they grow wild as well. So you may continue cultivating without knowing actually it is that. So we include the word knowingly even in 11.1. Thank you.
Yes, Margaret, then Esenu.
Thank you, Right Honorable Speaker. I want to buy your confession that there are youth deep down in villages who have never gone to towns, but they have been high on drugs. And I want to believe that there are it's as a result of these small plants within our homesteads. I want to say that we have treated cows with other drugs and they are not necessarily planted home, or we don't buy them from nearby. I'm from a cattle corridor area. Can we begin buying those drugs or plants from the licensed people that are going to be given license, other than allowing everyone to begin planting these plants that will end up being consumed by our own children and making them high all the time? I submit.
Thank you. For record, of our viewers outside, this is Honorable Margaret Rebiambo, whom I named Pimbarara, not Margaret Rabshija. Okay, and she's NRM, not independent. So for record of.
Thank you, Right Honorable Speaker, for that clarification.
Honorable Doctor, then I.
Thank you, Chair. My biggest concern is on cultivation, and already we have seen there are many issues around cultivation. One, we need to define cultivation. And we also, yes, because if you have 2 plants for your animals, if you have 10, are you cultivating? Secondly, my other issue is on where are we cultivating? Is it in the community where our youth can easily access the plantation and start taking it? I think, Honorable Chair, the issue of where we are planting is very important.
Thank you.
Thank you.
Now, honorable colleagues, I want to tell you this. In fact, the one of 2 plants is more of a danger to community than the rest. Because you don't care for them, you take them for granted, you think they are, but there is someone benefiting from those plants. Even killing one youth in a community cannot be compared to saving 10,000 cows. Yeah. A human being is difficult to replace. Colleagues, really, there are things where we have to be serious. I don't know if we are going to be a house that will sit here and say we shall allow growth of marijuana for feeding cows. 2 plants, 3 plants. Which kind of record shall we be setting? That's Honorable Reku, please, I want us to be serious when we are making this law.
Thank you, Chair. I'll go with your guidance that we should not allow these plants to be grown at home. There's a reason why people moved from the manufactured drugs to these plants. One of the reasons was that the manufactured plants, the manufactured drugs are not available and they're expensive in the communities. So what we need to do is the Ministry of Agriculture should take it off from here, that they should make these drugs available and cheaper in the communities so that farmers will be able to access them. Thank you.
Thank you. Honorable Jomonsi, then Honorable Hunda.
Right, Honorable Chair. I have been to a farm of this marijuana in Kasese, which has been licensed, yes, in Kasese, which is strictly prohibited from the public cannot access unless you have been authorized. It is properly fenced and they grow the marijuana for commercial purposes. I think we should not allow, like we have guided, our cattle keepers to just plant those 2, 3, 4, 5 plants. That's where the leakage and abuse may be happening, and the youth in the Eteeka getting drunk. And we have the law on NDA, which lists drugs, both human drugs and veterinary drugs, to be used in the country. I don't think these plants are listed in those on that list of drugs authorized. So I just wanted to appeal to those from the cattle keeping communities that we should be strict and disallow even those few plants which people keep in their farms, because the animals can still be treated using other drugs which the law prescribes.
Thank you. I had allowed Honorable Hunda.
Yeah, Chair, for us in the cities, we receive the effects much worse, because many of the youth, especially in the ghetto, those who are jobless, they depend on drugs. And we have been looking at the supply chain, where are these drugs coming from? And actually they come from the interior. Maybe the cattle corridor has also added a lot to Fort Portal demise. We lost one family, one guy killed the brothers and sisters in one family, 4 of them to death in Fort Portal. It happened. Actually, the crisis is so big, Mr. Chair, we need to find a mechanism. How do we help families who are already affected with these mentally derailed young persons? The families cannot afford the cost of living, of handling this kind of situation. So I think this law, as we get going, we need to put a mechanism how to support, the crisis out of our society, Chair.
It's already provided. Colleagues, we have to move. Okay, we have to move. Attorney General, there are other.
Honorable Chair and honorable colleagues, the NDA Act Cap 206, which was enacted in Uganda about 160 years ago, prohibited the growing of cannabis. The NDA Act of the Psychotropic Act of 2016 only made better what the NDA Act already had. So if anyone, Honorable Katoto, if anyone has been growing this cannabis casually, you have been committing an offense, because it's an offense already in the law. There is nothing that stops anyone from applying for a license, whether small or big. But that person will then be under the scrutiny of government to know you have applied for a license for 1 acre and you are responsible for that drug. Honorable members and colleagues, this one is one of the things that we are not saying you cannot do it by whatever size. I beg you, I implore you, colleagues, let's allow the minister to regulate this. I beg you.
Honorable colleagues, I now put the question that clause 11B amended as proposed. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 11 as amended.
I put a question that clause 11 as amended stands part of the bill. Those in favor say aye, and the contrary nay. The ayes have it. Now, the different proposed amendments that had been considered by both, when we are cleaning up, they are always captured, and we polish everything knowingly.
Clause 12.
Chair.
Thank you, Chair. Clause 12 is about power of entry.
Just wait a little bit. Now, I think we have a part for licensing in the bill. Yeah, because Honorable Jonathan Oduro had raised an important point, which I had expected you to respond to, whether you would be satisfied.
Honorable Chair, the Honorable Chair of the Health Committee did propose that an insertion be made after 3, that the minister shall make provision, regulations providing for the procedure and conditions to be fulfilled for a license to be granted under subsection 1 of this act for cultivation of prohibited plants. He did submit on that.
And I think it will be important for those regulations to come here and at Parliament, and then we shall ensure that all those issues are handled. We're gone. Chair, you were on table.
Thank you, Chair. Clause 12 is about power of entry in respect of government land and other land. For clause 12, there is substituted the following. 12, power of entry in respect to land. A police officer not below the rank of inspector believe that a prohibited plant was or is being cultivated on any land or in any premises without a license may, by himself or herself, with such assistance as in his or her opinion is reasonable, enter upon and inspect the land or premises. 2, a police officer who enters land or premises under subsection 1 may arrest or cause the arrest of a person suspected of cultivating the prohibited plant and confiscate the prohibited plants cultivated in contravention of the provisions of this act. 3, a person who obstructs a police officer or an authorized person in the performance of his or her functions under this section commits an offense and is liable on conviction to a fine not exceeding 50,000 currency points or to imprisonment not exceeding 2 years or both. The justification for this, Right Honorable Chair and dear colleagues, is to remove the distinction created by the provision relating to government and private land. 2, for completeness, to prescribe the powers that can be exercised by a police officer who enters any land, including the power to arrest a person who is suspected of cultivating the prohibited plant, as well as confiscating the prohibited plant. 3, to ease enforcement of the provision by allowing any police officer without distinction in rank to enter land for purposes of ensuring that prohibited plants are not grown on the land or premises. Right Honorable Chair, I submit.
Thank you. Chair, Honorable Minister.
I concur, Right Honorable Speaker.
Thank you. Honorable Nandara.
Thank you very much, Mr. Chairman. Mr. Chairman, plants are grown on land. When you say premises, what do you mean? I need to be clarified. That's number 1. Number 2, Mr. Chairman.
Someone has said they are grown in flower pots. A member here confessed.
Yeah, but that's land. Okay, maybe greenhouses it should be land. But the second one, Mr. Chairman, those days in Kenya, when a police officer wanted to make money from you, he would come with a bad object like the drugs and put in your pocket. Then arrests you and says he got you with what?
No,
drugs.
Honorable Nandara, you're referring to enforcement agencies of a certain country.
Okay, but I'm coming.
No. I want us to be cautious. I don't want a diplomatic role here, referring to enforcement agencies, legal agencies of a certain country, and you are saying they are involved in such acts.
Mr. Speaker, that is withdrawn. Mr. Speaker, I want us to know what mechanism were put in place. Have withdrawn.
Yes. You've awoken him.
Mr. Speaker.
Please continue.
What mechanism do you put in place to deal with the police officers who come in and allege that he has confiscated something here and arrest person, yet is for purposes of wanting either to cause injury or extortion?
Thank you.
Actually, if you, we have put, that's why we are defining it, not any police officer. We have put it at even the rank, assuming that at the rank of inspector, you are professional enough not to do acts that any other police officer below that can do.
Chair, I have not yet found the specific, but ahead we have a provision for vexatious arrest, malicious arrest, somewhere in the bill on police officers who will arrest, detain, or do such things. There's a punishment for them ahead.
18.
18, eh?
Yeah. Thank you.
Chair, I was just wondering, our local councils, our LCs, they actually know who are the owners of most of this land. And at the moment, in most of enforcement, we are actually excluding them with this one as well. In order to access somebody's premises, why can't we also include alongside the LC maybe? So that at least we avoid the problem Honorable Nandala is also talking about.
Honorable Minister for Internal Affairs.
Right, Honorable Speaker, we are specifically mentioning officers of a certain rank to avoid exactly what you are saying, abuse. And that's why we are restricting it to policemen.
Thank you. Honorable Seno.
Yeah, thank you, Chair. I heard with a lot of respect the response of the minister. But I think in the entire bill, we have excluded or not assigned the responsibility to the LC structure from LC1, 2, and 3. And yet this is a very grassroots problem. And in some communities, like some districts like mine, you have a police post almost per 2 sub can provide for the role of the LCs to be part and parcel of the process of identifying, informing, but also supporting the police in the arrest and the response and the respective activities taking place on this matter. Thank you.
Honorable, the role we are making is putting obligations. We're not supporting. Supporting when you're making a role, the supporting role doesn't need to be provided for under the role. We are putting obligations on people. So you want an LC one to be arrested for because someone in their village is dealing in a drug? Shadow Attorney General?
The proposal by my good friend, Honorable from Tesorand, would offend the provisions of Article 93 of the Constitution, because now you will be giving them responsibilities without the attendant certificate of financial implication.
Thank you. And also you remember these people dealing in drugs are very dangerous. They are armed. What? You send an LC one and he's sorted. I put a question that clause 12 be amended as proposed. Those in favor say and to the contrary nay. The ayes have it.
Clause 12 as amended.
I put a question that clause 12 as amended stands part of the bill. Those in favor say and to the contrary nay. The ayes have it.
Clause 13.
Thank you. Right Honorable Chair, the clause 13 concerns the licenses for export, import. Clause 14, I beg your pardon. Clause 14 is about licenses for export, import, manufacture, sale, production, or distribution. Clause 14, committee proposes that be amended, inserting immediately before the word issue, the word for medical purposes. B, by substituting for paragraph C, the following. prescribe the records to be kept by a holder of a license for sale, manufacture, production, importation, exportation, or distribution of specified narcotic or psychotropic substances. C, by numbering the current provision as subclause 1 and inserting immediately after the following. The National Drug Authority shall A, keep and maintain a register of persons authorized to sell, manufacture, produce, import, export, or distribute narcotic or psychotropic substances, and B, regulate and issue guidelines for conducting clinical trials involving narcotic drugs and psychotropic substances. Right Honorable Chair, this is one, in compliance with Article 4C of the Single Convention on Narcotic Drugs, 1961, to limit the sale, manufacture, production, importation, exportation, possession, or distribution of specified narcotic and scientific purposes. 2, prescription functions for the NDA, including regulating clinical trials and registering and maintaining a register of licenses to ease obtaining information pertaining to licenses granted for the sale, manufacture, production, importation, exportation, possession, or distribution of specified narcotic or psychotropic substances. I beg to submit.
Thank you. Committee on Health.
Thank you very much, Chair. We agree with the amendments by the Committee on Defense and Internal Affairs. However, we wanted to make an amendment by substituting paragraph C with the following. Prescribe the records to be kept for the export, import, receipt, sale, manufacture, production, disposal, or distribution of narcotic drug, psychotropic substances, or their precursors. Thank you. The justification is to provide for the record of precursors.
Now, honorable colleagues, I'm seeing this is a clause we don't need to stand over. We can handle. The moment we agree with precursors, we maintain it. The moment we don't agree with the introduction of precursors, it is dropped. Okay? In the cleanup. Yeah, because Honorable Songa.
Thank you very much. I want to thank the Chair Defense, Internal Affairs for the submission. But I wanted to give this information that these plans we are talking about, they are not only, they cannot only use them for medical purposes. With time, you will discover that they can be used in industrial textiles, paper, for making paper, printing papers, building materials, and other food ingredients. These are the lucrative income we can get from these other products. So I don't know why we should restrict them to only medical.
Thank you, Honorable Fidra.
Yeah, thank you, Chair. Clause 14 is so critical to some of us, where our constituencies are already engaged in anticipation in some of these plans. Now that they seem not to be catered for, making reference to Honorable, I've forgotten his name, but the fact that there are already communities who are engaged in the production, in the value chain of the entire plants in our community as a country. This law should work for everybody. To what extent shall we then involve in this law those who are already involved in the production? For now, we may not exactly determine for what purpose are they using these plants for, because the report earlier indicated that there's no substantive data to tell us how many are these plant growers in this country and for what purpose are they being used for. I want to make reference to West Nile, where we have farmers who are engaged in the entire value chain and all their livelihood is around some of these plants. So my submission would be that the law should cater and transform these communities to benefit for its transformation to be used as a medical purpose. How do we put it in the law? That's where I'm a little bit green about it.
Thank you. But the Attorney General, please wait. The Attorney General informed you much earlier that under the National Drugs Act, okay, it's illegal. They are committing a crime already. Now this law is saying, no, they can be licensed. So this is even better than the existing law. Okay? Yeah. Honorable Jonathan.
Chair, can we be guided by the Attorney General and the Chair of the committee? The intention of clause 11, as we had passed already, and now 14. The licensing, and from what I hear from colleagues, the word production. Is production under clause 14 the same as cultivation that we have passed under clause 11? Or the production being mentioned here refers to another process relating to the manufacturing of the drug and not the raw materials, not the production of the raw materials. So that, I think, it can guide us better.
Thank you, Right Honorable Chair. I think this one was for production is value addition. And when you go to the definition clause, it shows you how the separation is done. So cultivation 11 is dealing with the ordinary cultivation. The second one is the commercial production and sale and etc. So value addition. Thank you.
Yes, Honorable Ndiomujeng.
Thank you, Chair. When you read the heading of the clause, I see the word import. It confuses me because if we are talking about the narcotic substances within the country, how do we now involve ourselves in the importation of these substances? That's the clarification I wanted to see.
Thank you. Honorable colleagues, I just want to inform you, we shall not finish this bill today, okay? That one must be known because we have around 80 clauses. You can see where we are. So I want us to push up to around 7, then, and we cannot jump one clause, we go to the others. So we shall continue until, because I want us to give it enough time and enough attention. We do a very smart bill where every view is captured, okay? So no one should think we shall rush it and finish today. We are not able, considering the way I want us to do this. Yeah. Honorable Aisha.
Thank you.
Yeah, I will allow you.
Right Honorable Chair. Clause 11, we said the minister will license. However, I didn't even understand which minister. I rose then and wasn't given permission. We have 2 ministers in this case. We have the Minister for Internal Affairs and have the Minister for Health. And the amendment said the minister, they didn't add, but that said, my question is not at that. So clause 11 was about the minister licensing and clause 14 about the drug authority licensing. Are we going to have different organs of government licensing production of this drug?
Thank you. Now, on the minister, we have a proposal from the Committee on Health, okay? And when we reach on the interpretation clause, we define the minister. We put it, and when the House agrees, the proposal can be carried. We provide for both. But there is something which the chair wanted to clarify, or Attorney General, or whoever.
Thank you. The minister on clause 11, the minister is clear. One, it's minister responsible for health, and that's about the licenses. On import, we were told, no, yeah. Production, you already explained it. On import, Honorable Ndiomujeng is talking about, after licensing, we were told specialized seeds are imported after licensing. So that's the import we wanted to capture.
Okay. I had picked, yes. No, don't mind. I will allow you, Honorable and Honorable.
Thank you, Chair.
Let's do quick.
Chair, I had the privilege to be in one of the sessions of the committee. And some of the information that I have here was not captured. And I believe if I shared with a committee here, you might take it in good heart.
Did you sign the report?
Well, I'm not part of the committee, but I, as a member of parliament.
Okay.
Some of the information that was captured there by a group that was invited was that cat
That was captured or presented?
presented.
Okay.
Was that cat is grown among 17 districts in Uganda. And near about 7 million people are engaged in the activity. Right Honorable Chair, you always emphasize that we give evidence-based submissions. And we've certainly got some information that World Health Organization does not in any way consider cat as a psychotropic.
Are you submitting on clause 14?
I'm giving information where the member said.
No, Honorable. Are you submitting on clause 14?
Okay, I'll bring it on the schedule.
That's it.
Thank
Very
you.
good. Now you've known.
Thank you.
Thank you.
I'm happy with you, Honorable.
Thank you very much, Right Honorable Chair. Now, when we are looking at this 14, clause 14, there are psychotropic agent substances such as aviation fuel, which are beyond the jurisdiction of the National Drug Authority, which is at the disposal of very many young people. We have not housed it anywhere in this bill. I don't know if at all the chairperson of the committee took cognizance of the aviation fuel, which children sniff, where it comes from and its supply chain. Secondly, and this is a concern, Mr. Chair, we don't want to be caught up after finishing this law. I was reading the objects of the bill, and the object of the bill does not. Oh, Mr. Chairman. Yes. Mr. Chairman, the object of the bill, and I need your guidance on this. The bill, therefore, seeks to do the following. A, provide deterrent measures against local drug abuse. Establish mechanisms for the rehabilitation of the drug addicts. C, put in place measures to save Uganda from being a transit route for consumer of these drugs. D, facilitate the cooperation of the international community in the fight against drug trafficking. E, establish mechanisms for generating resources for the law enforcement agencies. In these objects of the bill, I don't see the nexus between the objects of the bill and cultivation. I want to be guided, Mr. Chairman. Why we are delving in the cultivation of narcotic plants vis-a-vis the objects of the bill. I can't see a nexus, but I can be guided.
Thank you. Please. Number one, if we go to the schedules, we shall have a list of all psychotropic substances. They'll be listed there. So if aeroplane fuel, aviation fuel and all that, it can be added and we see how best it can be controlled. But number two, if you look at the bill, I think it's when you look at the title of the bill, it says an act to consolidate and amend the law relating to narcotic drugs and psychotropic substances with respect to the control of the possession of, trafficking in narcotic drugs and psychotropic substances, and the cultivation of certain plants. It's already provided for. So we are doing very well. Yes, Shadow Attorney General?
My concern is on clause 14 is the wording, giving National Drug Authority the right to prescribe a manner in which certain matters must be done and the like. We know that the National Drug Authority cannot make regulations. We do not have that authority. The power to make regulations is by a delegated power from this parliament to a minister. So how will the National Drug Authority bring into force clause 14, 2, and 3? And how will the public come to know? And why will it do it in such a way that it does not offend the powers of parliament and those we've given the minister?
Government, Attorney General?
Thank you very much, Right Honorable Chair. And NDA is an agency of government and it is housed in the Ministry of Health. NDA can actually make regulations through its minister, and actually the NDA Act does provide for NDA making regulations, and we're providing for that. But when it comes to signaling the regulations to the public, it is done by the executive arm and the concerned ministry. There would be Ministry of Health. So there will be signal. NDA will prescribe, and then by statutory instrument, the minister will do it. To be done by Ministry of Health. That's what we do currently.
So in short, government won't work in silos. Government works together. Okay? Yeah. I had allowed, let me allow Doctor.
Thank you very much, Right Honorable Chair. On clause 14, I wanted to, the subsection B, where the exporters are supposed to keep the records. Now, I was thinking we need to have the duration for these records. For how long are they going to keep these records? For production, export, and import? Is it going to be the duration of the license or for some specific period? Thank you.
Thank you. Attorney General?
Yes, Right Honorable Chair, if you just allowed us a minute, try and draft. I think it's a legitimate requirement that how long, my understanding, if I could understand it correctly, is how long would the person be required to keep that record? Yeah. So if government went to ask for it, can government go there after 1 year, 2 years, or 3 years? If you just allowed us to just 1 minute to just draft, then we can come back to it.
Okay, as I pick other views, Honorable Komakech.
Thank you, Chair. Chair, it's on production. Of lately, confectionery shops produce cookies, cakes out of marijuana. And when we speak of production here, we are not capturing them. But then also performers, stage performers, they are those films they release during performance. What these businessmen do, or custodians of the business, they get marijuana and make it into films and release it to the people unknowingly, and they keep on going back to the same clubs. How does the law deal with that?
Now, what Honorable Komakech is raising is something a few people have confessed to me. Someone told me he attended a normal birthday party and was given cake. He only remembered when he was in hospital. Yes, our young people, you just see them high, and then now with TikTok, you know, they get high. And now also these films which they release to the public and for using, sometimes I'm told they put in so that you get charged hype and you cheer these musicians and performers. Now for you, you see yourself jumping the next day. you see yourself, you are cheering and what? Then you ask yourself, was that me? Huh? You mean what made me that happy? When someone indeed charged you without you knowing. You know, it's you're inhaling very dangerous substances. Honorable Chivumbi, There's something in regard to that.
Honorable Chair and Honorable Rulume will bear with me. We were in Thailand with the budget committee. Everywhere we went to, the soup, they would serve as an appetizer. Openly, could have leaves, and you could see them. And everyone enjoyed it. You see, that's why it is, everyone enjoyed it.
But how come it was never part of the report you presented here?
No.
The report of the delegation.
So the draft of the report just got exercised. So on the question of why on this issue is that you have to be very careful how it is applied. But I had an issue, very specific.
No, still on the same.
On the
Okay.
same.
I think Honorable Komakech, the issue has been clearly provided for. When you're in possession, production, and then you divert. Okay, I think that was under 4, under clause 4, where we sufficiently addressed all these issues.
So, but I've seen in the committee recommend, I've seen you trying to say sell, manufacture, production. What's the difference between manufacture and production? Do we really need the two? If we have captured the manufacture, do we need to capture production? Only this is by National Drug Authority. This is at a value addition, not the cultivation.
Yes.
So you have captured manufacture. Do you need?
The difference is humongous. Production, manufacture by value addition. Production is when you put 2, 3 together, you produce something different.
Okay.
Chair.
Now, I think that's a draft language, which ensures that indeed we don't leave room. You know, we don't leave room, for anything. So let's, colleagues, let's move. Attorney General wanted to give us information.
Thank you very much, Right Honorable Chair. We are proposing to address the issue of the time to insert a clause right after 1. We will renumber 14 to include 1 and then a 2 to read that the records prescribed under paragraph 1C above shall be kept by the person licensed for a period of 7 years. I beg to submit.
Thank you. Honorable Jonathan Odu.
Chair, I beg to differ. When you are issued with a license, the terms and conditions are prescribed. You don't need to prescribe it here in the law. All the licenses that are given, whether for aircraft, for everything, there's an accompanying terms and conditions. So the NDA will prescribe whether it is 7 years or 2 years, where should you keep it, where should you display it in your premises, all that cannot come here at this stage.
But which one is stronger? Because, for example, financial information by law, you're supposed to keep it for 10 years. 7 now? Yes, you have information, data, which you're supposed to keep for 2 years. So where do we find it much stronger? Under the license, so that we leave it to the minister in the regulation, or within the law here? You know?
Right Honorable Chair.
Yeah.
There is no contradiction whether you put it in the law or in the regulation. However, if you leave it to the NDA, you have left them the discretion to ask them to keep the records for 2 years. If you put it in the law, then NDA can only tell them to keep the records for 7 years.
To comply with the law.
To comply with the law. So whatever, I would propose that the member raised a very fundamental point, because here you're dealing with control of the use of these drugs. And therefore, Parliament may be interested in knowing that when a person is licensed, you don't have to rush to audit that person or check, that you can go in 7 years and find those records there. And if you do not find them there, they commit an offense. However, if you don't, then they may be given a shorter time. I'll propose, Right Honorable Chair and colleagues, that the members' proposal be carried and we make the provision here for 7 years. I beg
Let's
submit.
provide for it here. Honorable Nandara.
Mr. Chairman, first, the committee on the heading, it has said manufacture sale. I think there's needed to be a comma there because we could easily make manufacture, comma, sale. But what I wanted to raise, Mr. Chairman, is about importation. I heard the chairman said there are countries which allow us to import seeds. That means they have legalized the drugs being imported. Now, is it provided somewhere? What type of seeds should we import? Because we could import most dangerous seeds to this country. Number three, Mr. Chairman, you know this there's something, is it called gum for the shoes, where they put in the shoes? Most boys and girls go and get that gum, they inhale. They use it for repairing what? We can call it spot glue or whatever, but purpose for
that is contact glue.
Yeah, I think contact glue. Yeah. Now, how are you going to prescribe for such? Because it is meant for shoes, but guys are inhaling it to become mad.
Let's go to the schedule. When we reach on the schedule, that's where I think it was schedule 5, if I remember in the proposed bill, schedule 5. But he has raised an issue which I need you to address on importation, which was talking about.
Thank you. Before that, Chair, allow me, the law defines both manufacture and production in the definition part.
Okay, we shall reach.
We shall, so the member is catered for. Importation. The NDA Act on which now licenses are given, licenses have been given, importation of any seed is after license. And the regulations and all that are properly catered for. We only needed to be so clear and make sure we capture it.
But even then, we can capture it under the schedule. We can, yeah, on the schedule, yeah, we can capture all. Afidra?
Yes, Chair. From my small chemical background, those the compounds Honorable Nandala referred to and Honorable Baiga, in my understanding of clause 10, which we actually passed, would have recommitted it. It says supply of toxic chemical inhalants. My understanding is that this should have comprehensively been catered for under that, because these are chemicals that we inhale. I'll give you an example in some communities.
Honorable Fidra, the schedule is where we are listing all of them. Okay? If you've read the bill under schedule 5, we shall list all of them. We shall not leave anything to chance. I now put a question that clause 14 be amended as proposed. Those in favor say aye, to the content nay. The ayes have it.
Clause 14 as amended.
I put a question that clause 14 as amended stands part of the bill. Those in favor say aye, and to the content nay. The ayes have it.
Clause 15.
Chair.
Thank you, Right Honorable Chair and dear colleagues. Clause 15 is on penalty or failure to furnish information or produce evidence. For clause 15, there is substituted the following. 15, penalty for failure to furnish information or to produce records and documents. A person who fails or refuses to comply with any obligation to provide information or to produce a book, record, document, or other materials required under this act, or any order made under this act, be in compliance with the provisions of this act, gives information which is false, or produces a book, record, document, or other material which contains any statement which is false in a material particular, C, for the purposes of obtaining a grant or renewal of a license or any other authority under the National Drug Policy and Authority Act. 1, makes a statement or gives information which is false in a material particular, or 2, produces a book, record, document, or other material containing a statement which is false in a material particular commits an offense and is liable on conviction to a fine not exceeding 25,000 currency points or imprisonment for a period not exceeding 10 years, or both. Right Honorable Chair and dear colleagues, the justification for this is to make strict liability to enhance compliance. 2, in compliance with Section 37 of the Interpretation Act, to prescribe the maximum penalties that may be suffered by a person convicted for contravening the provision. I beg to submit.
Honorable colleague, I put a question that clause 14 be amended as proposed. Those in favor say aye, and to the contrary nay. 15. I put a question that clause 15 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 15 as amended.
I put a question that clause. No. The one we were handling was 14. 15. Yeah. Okay. I put a question that clause 15 B stand as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 16.
I put a question that clause 16 stands as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 17.
Chair.
But Chair, clause 15 concerns the owner of land to inform.
17.
I beg your pardon. Clause 17 concerns the owner of land to inform police officer. For clause 17, there is substituted the following. 17, owner of land to report to police cultivation of prohibited plants. 1, the owner of land or any other person with interest in land who has reason to believe that a prohibited plant is cultivated on that land in contravention of this act, or that he or that the land is prepared for a purpose of cultivating a prohibited plant, shall report that fact to police. 2, a person who contravenes subsection 1 commits an offense and is liable on conviction to a fine not exceeding 500 currency points or 3 times the market value of the prohibited plant, whichever is greater, or to imprisonment for a period not exceeding 5 years, or both. 3, for purposes of this section, a reference to the owner of land or any other person with interest in land includes the holder of a lease, a license, grant, permit, or other right in land, whether held individually or in association with others. Justification for this, but Honorable Chair and honorable colleagues, is for clarity and better drafting to impose an obligation on the owner or holder of a right in land to report to police wherever prohibited plants are cultivated on the land. 2, to enhance the effectiveness of the provision by prescribing a penalty for non-compliance. I submit.
Thank you. Honorable Gilbert Oranyi.
Mr. Chairman, this is where the problem is. As I raised the other time, why do you want to shift the burden to the landowner who has already given his land and somebody has already hired the land? For example, in our area, somebody may be given hills and hills, maybe 100,000 acres. Somebody is hiring. And I will not be in position to know what is happening in my land. Why do you want to give the burden to me to report that person to the police? Because I don't know what the person is doing.
But Honorable, if you listen to the chair, he says, who has a reason to believe that a prohibited plant is cultivated? If you don't know, you don't know. You don't have reason to believe. This is someone who knows. They are saying, if you know, then you must report. Okay? Yeah.
Thank you very much. the Attorney General guided that these prohibited plants can only be grown under license. We accepted that. Number two, earlier on, we had talked about giving responsibility to the LC1 chairman. And information came that these farmers are so powerful that we are putting the LC1 at risk. How about putting the owner of the land at risk? Thirdly, if we are growing these prohibited plants under license, does it mean the owner of land must check our certificate or our license? Thank you.
Attorney General.
Thank you very much, Right Honorable Chair. In law, we have a principle called the Ryland and Fletcher rule, that if you bring onto land something which is dangerous and it spills over to other people, you, the owner of the land, you're liable. Your interest in your land never ceases. So you cannot look aside and say something dangerous is being done on my land. I know it, but I've leased it out. You must also remember that the population and the public only knows the owner and does not know who is in the land. So the responsibility of the landowner is slightly different, actually majorly different from that of the LC1. Because if you know, and like the Right Honorable Chair said, the law only requires you to have reason to believe. If you don't have reason to believe, there is no burden on you. But what the law is saying that if you know and you don't say, then you commit an offense.
Thank you. A good example, Honorable colleagues, your neighbors can come to you and say, but they are cultivating marijuana on your land. Okay? And they say this is going on once, twice. Your road is very simple. To report it to police, then police will investigate. Okay? It's a really minimum requirement. Otherwise, we don't want people must know that they have obligations. We are fighting a very strong vice. Reuben?
Yes, thank you, Chair. For the case like where they grow wild, like in forest reserves, in the national parks, marijuana grows wild there. So what happens?
So you want now to own all the wild land in your area?
Because for clarity.
Yeah, no, Honorable, let's protect a member. Honorable, you're protected?
Yeah, for clarity, like in the national park and forest reserves, these primates, the chimpanzees, the baboons, actually they do self-medication. That's what they feed on.
Honorable, this clause is handling private land. It's not handling.
Asking where, how?
We will cross that bridge when we reach there. Yeah.
Yes, I just wanted to add the word immediately before who has reason to believe, the word knowingly, so that you capture the two legs. He may know, or if he doesn't know, but he must have reason to believe.
Okay.
Or he has closed his eyes from the truth.
Thank you. Honorable Nambesha, you had an issue?
Mr. Chairman, it is land under preparation we are talking about. And it would be very difficult for someone to know that this land is being prepared for planting a prohibited crop. Someone malicious may hinder development of a given land. And the report that it's being prepared for a prohibited crop.
Yeah, but if you don't know, you're not liable. And if you report, you know, yeah. Attorney General, you can help us on that.
I think the next clause will answer you.
Thank you.
Penalty for malicious entry, seizure, arrest, and etc.
Colleagues, let's move. I now put a question that clause 17 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 17 as amended.
I put a question that clause 17 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 18.
Chair.
Right, Honorable Chair, clause 18 is about penalty for vexatious or malicious entry, seizure, or arrest. Clause 18 of the bill is amended. A, in the head note, by deleting the word vexatious and etc. B, paragraphs B and C by substituting for the words vexatiously and unnecessarily the words without reasonable cause. Justification: to remove words which are incapable of exact definition in order to enhance the effectiveness of the provision. I submit.
Okay. I put a question that clause 18 be amended. Clause 18. Switch on.
I believe under this clause we can include a clause to deal with planting of evidence by
doing what?
Planting evidence, as in somebody what Honorable Nanda had mentioned, somebody bringing an illegal substance within the premises of the suspected person.
But that's
maliciously.
Yeah, that's malicious.
But it does not specify on that, Chair. If you look at it properly.
Attorney General, can you satisfy your colleague?
Thank you, Right Honorable Speaker. The offenses that already exist in law, in the penal code, if you frame someone, if you cause malicious prosecution, those already exist. But here, this particular act is introducing an offense against the police officer, because the police officer under this act has been given power to enter and seize, which he did not have in any other law. Now he has been given power to enter and seize and even arrest someone under this law. So they are saying that if you exercise that power maliciously or without reasonable cause, you will be charged. But if you maliciously frame someone, there are other offenses. So this is a new offense created by a new obligation created for the police.
Thank you. Meaning the law is not applied in isolation. Okay.
Chair, I just wanted to inquire from that on the general. When you look at the clause, the head note uses the word malicious, but the body of the clause, the word malicious is omitted. Could we substitute it with the word recklessly so that the head note marries with the main body of the clause?
Or we can amend the head note. Okay.
My proposal would be that in clause 18 subclause 1b, immediately after the word vexatiously, we instead of the word unnecessarily, we substitute the word unnecessarily with maliciously. So vexatiously and maliciously. Actually, it shouldn't be and, it should be and stroke or maliciously says, so that the two may be used interchangeably. Okay.
Let's read it all together, because the committee was saying you delete or, then you use without reasonable cause.
So my proposal would be vexatiously and stroke or maliciously seizes the property of any person and the rest.
Now the committee is arguing, okay, that those words, they are incapable of exact definition. That was the argument of the committee. So can we reconcile our positions?
Honorable colleague, if I could just convince you, I think I was convinced by the committee, because the committee says without reasonable cause. So the burden has been shifted to the police officer to show what was reasonable cause. I had this evidence, I had this report, I had this. But when you say malicious, I mean, I may have reasonable cause, but it is seen as if it is malicious. So that's where the thing, but to accommodate all, we could say maliciously and without reasonable cause. That caters for all of them. So maliciously and without, or
yes,
without, so vexatiously and or maliciously and or without reasonable cause. Yes.
Okay.
Next,
Honorable Enos?
As much as I'm not satisfied with Attorney General's explanation on planting evidence, I also believe that giving 1 year or both for a police officer who has maliciously arrested or planted evidence against an individual, I think 1 year is not that deterrent enough. Because chances are that if you look at countries which have been fighting with the problem of drug enforcement and all that, actually drug use and enforcement, police officers are using it to deal to sort out scores with their opponents. So I think we need to be specific on this and put a stronger measure on dealing with specifically police officers or government officials maliciously
Authorized person. So how many years are you proposing?
Actually, when you look at Philippines, it's death sentence. If you read, yes, you read their law, you can check. They
be
put it,
fair.
I'm giving.
Listen,
okay.
Listen, Honorable. We have been proceeding. Okay.
Okay.
You don't bring something out of nowhere. It doesn't fit within the range.
Okay. Okay. I suggest for me 15 years.
15 years? But colleagues, you're proposing as if you're talking to each other. I need yes, Honorable Isaac.
Thank you, Chair. I would actually propose up to 10 years.
Up
I think
to 10
15
years.
would be a bit more.
Okay, I put a question. What about, because now you're looking at the penalty, but the currency points, Honorable Minister? Also the currency points need to be.
I understand the concerns of members, but I wouldn't want to tie the hands of policemen to make them timid, even when they mean well. And there's a thin line between malice and unreasonable cause. So I think 5 would be okay.
No, but Honorable Minister, you see, it means that police officer is a dealer. Otherwise, where did he get it from? Say, where did he get it from? He's also a dealer. So if we are putting obligations on citizens, even the ones who are enforcing the law must have obligations, serious obligations on them. Otherwise, the drugs are easily used, and you know, and once they frame you as a drug dealer, your reputation in society and what is finished. Honorable colleagues, I put a question that clause 18 be amended as proposed. Those in favor say aye. To the contrary, nay. The ayes have it.
Clause 18 as amended.
I put a question that clause 18 as amended stands as part of the bill. Those in favor say aye. To the contrary, nay. The ayes have it.
Clause 19.
Because we are going up to around 7 p.m. So let's clause 19.
Thank you, Right Honorable Chair. Clause 19, penalty against a police officer. Clause 19 is amended by deleting paragraph B. Justification. 1, a drug addict has a right to life, liberty, and therefore being provided with custody or accommodation is part of life. 2, provision is ambiguous and imposes enforcement challenges since it prohibits the giving of custody to a drug addict or any other person who is charged with offense under the Act, yet it is the role of police to arrest and give custody to the persons. So the new clause insert a new clause immediately after clause 19. Okay. First.
No, you finish presenting the position of the committee, then the Attorney General will come in if he has a, Because I'm reading from the report.
Yeah.
And he's not
New
reading
clause.
outside.
Insert a new clause immediately after 19. It's a penalty for conspiracy, inciting, aiding, or abetting, commit.
No, Honorable, what the Attorney General is saying, let us first finish 19. Then issues of new clauses will come later. Okay? So can we sort 19?
Right Honorable Chair, we don't agree that a police officer has a duty and an obligation to give custody to any person who is charged with an offense under this act. We don't agree that a police officer has a duty to give a drug addict custody. In fact, the police officer has a duty to ensure that a person who is charged with an offense under this act is presented to the police, and a person who is a drug addict is presented for rehabilitation. So if the police officer is the one harboring the person, then we don't agree with the committee. We propose that this clause remains here in the bill. We beg submit.
Now, meaning the drug addicts, we are going to start suing police officers for not accommodating them.
No, I think right now, Chair. Yes, right now, Chair, I agree with Attorney General. When you look at the clause, it refers to the police officer or a person who may be a drug addict who has been charged for an offense under this act. And instead of being treated as the law requires, a police officer decides to hide him or her in a hotel or a lodge. So that's what the law is trying to prohibit. He has a duty to make sure that this person who is charged under the act is either in a prison or on remand somewhere, but not in a leisure place.
Kabura, you have an issue?
Yes, thank you, Chair. I wouldn't want us to restrict ourselves only on police officers. We also have government officers, including even ministers who can do it. So I think we should be more broad and include government officials.
Honorable, here we are talking obligation of enforcement under the law. So a cabinet minister and
Chair, wait a minute. Chair, when you look at
I put a question.
Wait a minute, Chair.
I put a question that clause 19 stands part of the bill. Those in favor say and to the content.
Clause 20.
We are here to make a law. We are not here to start being general, picking everyone on the street and giving them obligations under the law.
Clause 20.
But we had a new clause, which the committee was proposing. If we maintain clause 19, do you still need to bring this new clause? That would be the question.
Yes, the new clause, Right Honorable Chair, where proposal for a new clause is penalty for conspiracy, inciting, aiding, or abetting to commit an offense. A person who conspires with, incites, aids, or abets another person to commit an offense under this act commits an offense and is liable on conviction to imprisonment not exceeding 10 years. Justification for this is to create an offense for any person who conspires with, incites, aids, or abets another person to commit an offense under this act. I submit.
Thank you. Attorney General.
Right, Honorable Chair, we have
Shadow Attorney General.
Yes, we have the Penal Code Act, which provides for offenses of this nature, conspiracy, incitement, and the like. We do not need a specific clause in this. We will use the Penal Code. That's my view. And think.
Attorney General.
I entirely agree with the Shadow Attorney General. I beg that this clause be dropped.
Chair, committee chair.
Now that we know that these offenses are provided for in our statute books, I concede.
Thank you.
Clause 20.
Chair. I think I put a question that clause 20 stands part of the bill. Those in favor say and to the content. The ayes have it.
Clause 21.
Chair.
Right Honorable Chair, clause 21 is forfeiture of conveyance implements. Clause 21 is amended. A, by substituting for subclauses 1 and 2, the following. 1, a court which convicts a person of an offense under this act may, in addition to any other penalty prescribed under this act, order the forfeiture to the state, any chemical, machinery, equipment, implement, pipe, utensil, or other article used in the commission of the offense, or B, any conveyance used in the commission of the offense for carrying any narcotic drug or psychotropic substance, or for carrying any chemical or any machinery, equipment, implement, pipe, utensil, or other article used in the commission of the offense. B, by inserting immediately after subclause 1 the following: notwithstanding subsection 1, the owner of a chemical, machinery, equipment, implement, pipe, utensil, conveyance, or any other article which is used in the commission of an offense and was not involved in the commission of the offense may apply to court for restoration of the chemical, machinery, equipment, implement, pipe, utensil, conveyance, or any other article. Right, Honorable Chair and dear colleagues, the justification for this is for clarity and better drafting to merge subclause 1 and 2, since they relate to the same subject matter. 2, to require the forfeiture to be ordered by court in order to prevent abuse. 3, for completeness, to allow the owner of a conveyance and other implements to apply for restoration of matters forfeited by the state. I submit.
Honourable Minister.
I concur.
Honourable Jonathan.
I needed clarification here on this forfeiture. If the machine, or especially the machinery or the conveyance is used, I wanted to add the word exclusively for commission of the crime, because if I am part of a passenger vehicle or an aircraft transporting passengers, but somebody also uses it tactfully to convey the drug, would you be justified to say that the whole conveyance or the equipment is part of it?
Attorney General.
Right, Honorable Chair. It will be impossible to find any item which is exclusively used for the purpose of commission of a crime, such as this one. So you'll find people are transporting their cargo normally, but they know that they're also transporting drugs. So it's very difficult to find a car which is used exclusively for the purpose of commission of drug trafficking. So if you say exclusively, we may find ourselves in a position of impossibility to ever find any vessel for that purpose.
Yes, Honorable.
Chair, from experience, I've watched documentaries where drugs pass through, even here in Entebbe, and it's discovered in Dubai or in another airport that actually the drugs have passed through and these people have sat in a certain airline. Will you detain that? That's my point, I'm saying. I don't know if I'm clear enough.
Attorney General.
I think what the committee has done now is it has taken away the authority of a state to just take, and has included court, where court now gives the opportunity of the owner of that vessel to give such an explanation such as yours. And the judge will then decide whether or not it is a convincing explanation, or if he's not convinced, order the seizure. I think what the committee has done, Right Honorable Chair, is it has now created the avenues to address such challenges.
Okay. I put a question that clause 21 be amended as proposed. Those in favor say aye to the content A. The ayes have it.
Clause 21 as amended.
I put a question that clause 21 as amended stand as part of the bill. Those in favor say aye to the content A. Ayes have it.
Clause 22.
I put a question that clause 22 stand as part of the bill. Those in favor say aye to the content A. Ayes have it.
Clause 23.
Chair.
Thank you. Right Honorable Chair, clause 23 concerns application for restraint order. Clause 23 is amended. A, by substituting for subclause 1 the following: where there are reasonable grounds to believe that any person has committed a specified offense, and after investigations have commenced in relation to the offense, the Attorney General may apply to the court for a restraint order in respect of any of the property which the Attorney General believes are proceeds of crime. B, in subclause 2, by substituting for the word deposing the word for deponing. 3, in subclause 3, by substituting for paragraph A and B the following: A, after the investigation in subsection 1 is concluded and it is determined that no specified offense was committed by the person against whom a restraint order is sought. B, where after the investigation is in subsection 1, the person against whom a restraint order is sought is charged with a specified offense, and a final decision for conviction is given in respect of the commission of that offense by the court. The justification for this, honorable colleagues, is 1, to restrict the restraint order to only those properties that can be proved to be proceeds of crime. 2, for clarity, to ensure that the restraint order is not granted where a person is not charged with an offense, or the person, if so charged with an offense, court finds the person not guilty. I submit.
Honorable Nandara.
Thank you very much, Mr. Chairman. Mr. Chairman, I want the chairman to help me to understand that the property, if somebody got, say, from the proceedings, say $2 million, and you know he has, some of it he has bought shares, you may have seen, some he has not bought, some is, how will you assume that the only property he has is the only one from proceedings of sale? Supposing he used even to pay a loan to cover one of the assets which he had got.
Attorney General, before you come in, the opposition chief whip.
Yeah, supplementary to what the Honorable Nandala is raising. If this particular restraint order is not restricted, is restricted only to properties that are acquired from money from illicit drugs, how do you determine which criteria? How what kind of magic will you employ to know that these are properties that are, because there may be those that were acquired through legal means? Don't you think this is this can easily be abused?
Yeah.
How would you determine that these are properties acquired through illicit drugs?
Honorable Isaac.
Thank you, Chair. Furthermore, to that, I concur with what Honorable Nandala said, but also we do not actually know exactly when these people started the business of actually dealing in psychotropic drugs. So it may actually present some challenges in actually knowing when they actually started doing the business and which properties were acquired within that period of time.
Thank you. Attorney General, Doctor, you may first.
Thank you, Chair. Mr. Chairman and honorable members, investigating cartels of drug lords and people involved in drug crime is a very slow, tedious, and meticulous process. And it's cross-cutting, involves tracking of accounts, looking at the history. You just don't wake up one day and pin somebody for illicit wealth or illicit drug use. So there's going to be a lot of cross-cutting involvement, Financial Services Authority, and so forth. So in my opinion, I think let's give the law the benefit of doubt to track. It's like investigating corruption. How do you say that this property is from corruption and this is from? Thank you.
No, but the members are concerned on misuse or abuse of such a role. And you find I'm targeted, and therefore you say no, you know, without going on record properly. You've had some members have have taken money to be kept somewhere because they might grab it. Okay. So how do we, Attorney General? And I think they managed to defeat you on that. You
Yes.
never grabbed.
Yeah.
How-
So, like the Honorable Chair is saying, proceeds of crime are very difficult to trace. But this clause as it is actually couched in such a manner to avoid abuse. Because we are saying that you can only restrain property which you prove is actually a proceed of crime. If you remove that, then what Honorable Nandala is proposing would mean that if a person accuses anyone of having participated in this kind of crime, then they can take even the property which was not the subject of the proceeds of crime. So what we are saying here is that the burden is on the state before it attempts to attach anyone's property to prove that it is actually from the proceeds of crime. Like Honorable Yume said, it's a process that we are now engaging in very heavily under the Financial Intelligence Authority and the anti-money laundering. There are processes now that are being developed to try and trace this money and follow money of crime. But the clause as it is, Right Honorable Chair, is actually protecting members against abuse.
I think, colleagues, if the burden, okay, is on the state and it is court to determine, I think we must give our judiciary a chance.
I really agree with the amendment, especially because the original framing of the clause was hanging. It had not connected the property to the proceeds of crime. But with this particular amendment is okay, and I support it. And I invite my people on this side to agree with me.
I put a question.
Chair, thank you. I had an issue with these ex parte procedures, and I wanted the Attorney General to convince us, because we are dealing with a property
Ex parte
and
procedure.
property rights. Why would you want to proceed ex parte and yet the person? I know that it's provided, but there should be some good justification before.
I can proceed ex parte, the Attorney General could proceed ex parte, but the court could order the person. But why it is being proposed to proceed ex parte is normally when you get to this point, the person who is the subject of this offense is vanishing and is taking benefit of the assets in order to move them from one jurisdiction to another. So if you require them to come back and appear in court before you can get the order restraining the movement of that asset. For example, if it is cash in the bank and you say, first find the alleged drug trafficker, bring him to court. By the time we're done with the process, all the money would be gone. So that's the reason. Beg to submit.
Thank you. I now put the question that clause 23 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 23 as amended.
I put a question that clause 23 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it. Now, colleagues, I had said we stop at 7, but can't we reach clause 25? Just 2 clauses. We reach on 25. Yeah, 2 clauses, we reach on 25. And the traffic is building up, so, but I know we are getting tired and I don't want us to handle. So let's stop at 25. Okay.
Clause 24.
Chair.
Right, Honorable Chair, clause 24, about transfer after notice of application for restraint order. Clause 24, the committee proposes that it be amended in subclause 2 by substituting for the words informs the court of an intention to appeal against the dismissal, the words files a notice of appeal. Justification: an appeal is originated with the notice of appeal, not the mere expression of an intention to appeal. I submit.
Attorney General, I think that's straight.
No objection, no objection.
I put a question that clause 24 be amended as proposed. Those in favor sign to the contrary. Ayes have it.
Clause 24 as amended.
I put a question that clause 24 as amended stand as part of the bill. Those in favor sign to the contrary. Ayes have it.
Clause 25.
Chair.
Honorable Chair, clause 25, the statement of assets and examination of respondents. The committee proposes that we delete clause 25. Justification: clause 25 contravenes clauses 23, since in clause 23, the Attorney General must be possessed with information relating to the property sought to be included in a restraint order before an application is made. 2, this provision will therefore have the effect of reversing that duty by imposing an obligation on a person against whom a restraint order is made to prove that his or her property are not obtained from proceeds of crime before he or she is charged or convicted of an offense. This provision will allow a person to be put to his or her defense, yet she has not yet been convicted of an offense. 3, clause 25 will allow the confiscation of a person's property without that person having committed an offense. I submit.
So in short, this clause was allowing the Attorney General to even speculate. Yeah, you know, and yet you must first prove Attorney General.
Actually, Right Honorable Chair, we are proposing that this clause be left because this one is giving the discretion to the court. This is for the court. It reads, the court may, before or after an order is made. So what the committee is saying is that the court can't ask, the court must rely only on what the Attorney General is saying. So if the Attorney General comes and says, this property belongs to person X, the court cannot ask. This provision is saying the court may ask, that the court may before direct the respondent to submit within a specified time a statement of his or her assets and liabilities. The Attorney General has gone to court, has told the court, I want to attach all these assets belonging to so and so. The court looks at it and says, maybe I should hear from the other person first. What this provision is saying is take away the discretion of court. This has nothing to do with what the Attorney General can do. This has everything to do with the court's discretion to exercise the discretion within its courtroom in order to find evidence sufficient to make a just cause. I beg to submit.
Thank you. Now, colleagues, Attorney General is saying if we delete, then we are limiting powers of court. Okay? And yet court, all of us, we look at it as independent. That's why we go for justice. Therefore, we should leave court to play its role. Chair of the committee. Honorable Nandara.
Mr. Chairman, it is saying direct the respondent submit within a specified time a statement of his or her assets and liabilities. Mr. Chairman, if it's a businessman, he has submitted his returns to URA. I'm just giving an example of that, or URSB. Now, Mr. Chairman, if he again court comes and says, submit your assets and liabilities, do you want to do the taxation? Do you want to do this? This should not be the job of the court. Attorney General should be coming and say, I have discovered this man has assets. He did X, Y, and Z. I have got a restraining order. He has nothing to do with this asset, but now a court to impose a charge. This one, produce accounts again, is you're imposing a charge on a person who is saying, I am innocent until proved guilty.
But here, it's the court may. Yeah. No, you can't say it will. The court may. Honorable Nwagawa.
Yes, Honorable
Shadow
Chair.
Attorney General, yeah.
My biggest worry with this clause is that we are trying to criminalize what would ordinarily be a civil matter. Because we are now looking at property proceeds of crime. And after court has maybe failed to get from the Attorney General the proper evidence, then it says, you respondent, bring your assets and liabilities. And yet this particular clause is not even tied to the assets and liabilities related to proceeds of crime. It gives the court, yes, the court has powers, wide powers, but we may also have to balance the rights of citizens who may be flimsily brought in the court, and the Attorney General has no record of properties, and they want to know Honorable Kafenje's properties even when they are not connected to proceeds of crime. I'm very uncomfortable with this particular clause.
Attorney General, I just wanted to ask so that I'm able to guide the House well. If we deleted this clause, can't court under its general authority still order it?
It can still do so.
Yeah. So if it can, what
Can
do
still
we-
do so.
Okay. Now, I put a question that clause 25 be deleted as proposed. Those in favor say aye, and to the contrary nay. The ayes have it. Honorable colleagues, I think we've done up to clause 25. We've done a good job. So, Honorable Minister. No clerk, sorry.
Motion for the House to resume.
Honorable Minister.
Right Honorable Speaker, I beg to move that the House do resume and the committee of the whole House reports thereto.
Yes, Honorable colleagues, I put a question that the House do resume and the committee of the House reports thereto. Those in favor say aye, and to the contrary nay. Ayes have it.
Report from the committee of the whole House.
Honorable Minister.
Right Honorable Speaker and honorable members, I beg to report that the committee of the whole House has considered the bill entitled the Narcotic Drugs and Psychotropic Substances Control Bill 14 of 2023 and passed clauses 13, 16, 19, 20, and 22. Passed with amendments clauses 1, 3, 4, 5, 7, 8, 9, 10, 11, 12, 14, 15, 17, 18, 21, 23, and 24. Deleted clause 25. Stood over clauses 2 and 6. I beg to move that the report from the committee on the whole House be adopted.
Honorable colleagues, I put a question that the report of the committee of the whole House be adopted. Those in favor say aye, and to the contrary nay. The ayes have it. I want to thank you, honorable colleagues, for the spirit of working together. This is a good law. I'm sorry, we shall move slowly by slowly and make a good law. I don't want us to rush in anyway. I want to pick your views that at least they go on record, even where you don't agree with the rest of the colleagues, at least you go on record, isn't it? This is a very, very critical bill. So tomorrow we shall ensure that indeed we push. I can see we still have around 30, 35 clauses to handle. So we shall move and we finish all of them. If we don't, we shall push up to Tuesday, but ensure that we give ample time with regard to this bill. House adjourned to tomorrow at 2 p.m.
Olunaku bwe lutyo bwe lutambudde mu Palamenti y'eggwanga Uganda. Mubirabye bulungi etteeka ku biragalalagala liisiddwa era n'akwatibwa wa kubonerezebwa wa kuwa engassi ojja kajjuutuka. Lwaki okolesa ebiragalalagala, otunda ebiragalalagala, otambuza ebiragalalagala, osuubuza ebiragalalagala nga tolina lukusa lukukkiriza. Okuggyako bonna abalina olukusa okukola research okubijjanjabisa bokka be bakkirizibwa okuba n'ebiragalalagala. Naye obanga tolina lukusa kajja kujjuutuka, n'olwekyo olina okwetereeza n'okulaba nti naye tokola musango munene okusinziira ku Paalamenti olwaleero nga bw'ebikoze. Olina okuba nga omanyawo olina okukoma ku kiki olina okukola n'ekiki otalina kukola. Bwe bityo bwe bitambudde olunaku olwaleero. Mbaagala nnyo mwenna abaddeko. Mukama Katonda nsaba agira abankuumira. Tujja kuba tuddamu tuwaye. Mweraba.